Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President, urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Rural Development and Local Government, can the Minister indicate how many employees will be affected by the recent policy decision taken by the government to reduce the number of teams attached to each CPEP contractor?
Minister of Rural Development and Local Government. Minister, I remind you, you have 2 minutes.
Thank you very much, Madam President. I want to thank Senator Mark for the question. Madam President, let me make it clear that contrary to newspaper reports that the CPEP company is not reducing its workforce by 2/3. Madam President, the Community-Based Environment Protection Enhancement Program stands firm by its vision statement of securing the future by protecting and enhancing the physical environment while building our communities through entrepreneurship. Its corporate strategy is built on 5 priorities: core business and entrepreneurship, community and stakeholder involvement, business transformation, organizational development, revenue growth. CPEP's core mandate continues to be, firstly, the protection and enhancement of the environment, thereby mitigating public health risks, life, like mosquito breeding grounds. Secondly, but closest to heart, the generation of employment and entrepreneurship across all communities. Recently, Madam President, 3 contractors, teams comprising of 30 workers each, were reduced to 10. These 3 teams, Madam President, does not include the whole of CPEP. This, Madam President, resulted in 60 employees being temporarily displaced. We expect, as this happens within CPEP from time to time, all 60 workers will be reintegrated into the program. Madam President, as we continue to battle the ravages of an ongoing pandemic, we continue to place the safety and protection of all workers under the CPEP Company Limited at the center of our decision making. Thank you, Madam President.
Senator Mark.
Can the Minister indicate to this Honorable Senate where this situation occurred, seeing that it is not widespread? Can I ask the Minister to clear the air for us as to where this reduction took place?
Normally, Senator Mark, they have environmental work areas, and this happened in the eastern area of the country.
Yeah. Next question, Senator Lutchmedial. You have to.
Thank you, Madam President. Minister, I know that part of my question may have already been answered, but just for the record, can the Minister state the reasons why CPEP contractors were given the instructions to reduce the teams from 3 to 1?
Minister of Rural Development and Local Government.
Once again, and thank you to Senator for the question. Following an assessment, it was decided to redeploy workers to achieve equity across the environmental work areas. As stated before, this is a temporary displacement. Workers will be reintegrated into the program, and approximately 60 workers were affected.
President, a supplemental. Thank you. The 60 workers that you indicated would have been affected, and you said that they would be redeployed. Do you anticipate that they would be redeployed in different areas from where they were previously stationed?
Minister.
Thank you, Madam President, and thanks for the question again. They will be redeployed, as I said, and they will be redeployed within the environmental work area as before.
Senator Lutchmedial. That's it.
President.
Next question, Senator Mark. Just
Thank you, Madam President. To the Honorable Minister of Social Development and the Family Services. In light of the recent fire, which completely destroyed a home in Gasparillo, can the Minister indicate what steps will be taken to assist the family that was rendered homeless?
and Family Services.
Thank you, Madam President. Following a report of the fire which destroyed the home of a 58-year-old woman and her son on January the 23rd, the Ministry of Social Development and Family Services stepped in to provide assistance to the family. Earlier today, officers attached to the National Family Services Division of Aging, as well as our National Social Development Program, visited the family and immediately assessed the damage so that assistance could be provided. Fortunately, no one was injured at the house when the fire occurred. Mrs. Mohammed stated that she lost food and clothing in the fire. Everything else was completely lost, and she is in possession of only a few personal items. She is currently residing with her neighbor from across the street temporarily. The family is on the ministry's public assistance database and has since been offered counseling and psychosocial support by the National Family Services Division of the ministry. The victims were also referred to the Social Welfare Division for rental assistance, as well as assistance to replace furniture and household items destroyed by the fire. To the Social Welfare Division, household items up to a maximum of $10,000 may also be replaced. The family was briefed on the housing repairs grant offered by the ministry, which amounts to a maximum of $20,000, available to persons who were affected by a disaster. Affected persons may claim for minor house repairs in the sum of $20,000 worth of materials from the ministry National Social Development Program. The family was also given a food hamper during the visit, and the ministry will continue to work with the family in order to assist with bringing some sense of normalcy to the situation. Thank you.
Yes.
Next question, Senator Mark.
Thank you, Madam President. To the Honorable Minister of Works and Transport, in light of the recent collapse of the roadway at Mosquito Creek, can the Minister indicate the arrangements to be put in place to ensure that commuters are not negatively affected?
Minister of Works and Transport.
Madam President, and thank you, Senator Mark, for the opportunity to clarify the failure of the slope at the Mosquito Creek. Madam President, the construction of the Mosquito Creek incorporates 2.4 kilometers of northbound and southbound carriageway. Approximately 2 kilometers of the southbound carriageway has been successfully open to traffic since 2019. Within the ongoing construction zone of the 2.4 kilometer northbound carriageway, a location 180 meters failure zone has occurred. This construction zone is not completed and have not been open to traffic, and therefore does not create an impact for the existing flow of traffic at the Mosquito Creek, nor does it pose any immediate threat to vehicular traffic on the road users on the Soundtrack Road. Thank you.
Senator Mark, the time for urgent questions has expired.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you, Madam President. Madam President, there are 4 questions for oral answer today. Government intends to respond to 3. Number 53 was previously deferred, Madam President, and the government is not in a position to respond to it today. And there are 2 written questions which were also deferred previously. These are very complex questions. The responses are being worked on, and accordingly, Madam President, we are not in a position to respond today to these written questions. I thank you.
Senator Mark.
Yes, thank you, Madam President. Madam President, question number 37 to the Honorable Minister of Public Utilities.
Leader of Government Business.
Thank you, Madam President. Madam President, the report of the Water and Sewage Authority on the fire which occurred at a Port of Spain supermarket on Saturday, 13 November 21, indicates, among other things, that WASA, on being notified of the occurrence of the fire, immediately boosted water pressure on the high-pressure fire hydrants in Lower Port of Spain and notified the fire services accordingly. As a consequence, the fire service appliances combating the fire were able to refill from freshwater hydrants on Wrightson Road and Dock Road, St. Vincent Street and South Quay, and Abercrombie Street and South Quay. Additionally, WASA trucks collectively supplied 18,000 gallons of water to the fire service appliances involved in suppressing the fire. Madam President, it should be noted that fire hydrants fall under the responsibility of the Trinidad and Tobago Fire Service, not the Ministry of Public Utilities. And the majority of the hydrants in Lower Port of Spain are actually serviced under the old saltwater system. And in part, that is the reason why we have some challenges in that part of the country because of the issues with the old saltwater system. In this case, any deficiency there was compensated by the quick action of WASA by boosting the water pressure and also using the water trucks to supply an additional 18,000 gallons. Having said that, Madam President, Ministry of Public Utilities and National Security are working to develop a program relating to fire hydrants throughout the country to ensure that they are able to provide the water and they can respond when required to, and then specifically to work to address the issues with the old saltwater mains in Lower Port of Spain. Thank you very much.
Senator Mark.
Yeah. Madam President, can the Minister indicate what concrete measures are being taken by the government to address this salt water crisis that will impact and continue to impact on the supply of water via the hydrant system? Can the Honourable Minister explain to this Senate what measures are being taken to fast-track that particular challenge?
Madam President, I wouldn't say it's a crisis. I would say that it's a problem. And the Ministries of Public Utilities and National Security are collaborating to develop and implement a comprehensive program to ensure that fire hydrants throughout the country are fully functional in the event of an emergency, commencing with an audit to determine the operability of hydrants in the towns, cities, and boroughs around the country, and an examination of the feasibility of continuing the old saltwater main system in Port of Spain, or installing a new solution using grey water or potable water as found appropriate. In the first instance, it is proposed to implement a preventive maintenance program for fire hydrants comprising of regular testing, inspection, and scheduled maintenance. Thank you.
Senator Mark.
Madam President, I'll go on to the next question.
Next question, Senator Mark.
Yes. Question number 38 to the Honourable Minister of Health.
Thank you very much, Madam President. The Tobago House of THA has also advised that Dr. Nathaniel Duke has been appointed Chief of Staff of the hospital, and a commissioning team under his leadership is proceeding to operationalize the hospital, including recruitment of staff. Barring unforeseen circumstances, the THA has advised that the hospital will be operationalized in the first half of the calendar year 2022.
Senator Mark.
Yes, thank you, Madam. Can the Minister indicate with the operationalization of this hospital, can the Minister indicate to us whether he has information to share with this Honourable Parliament, the Senate, how will this opening of this very important hospital serve to ease up the crisis affecting the people of Tobago, particularly in the case of COVID-19 cases? Can you share with us your vision or what information you would have collected from the THA on that matter?
Minister of Health.
Thank you. So we must be careful how we use the word crisis. We are in a global pandemic, as all countries around the world. The additional space at the Roxborough Hospital will in no short measure add to hospital bed capacity, ICU capacity. So it is envisaged that when it is operationalized, it will indeed have a very positive impact on the treatment of COVID in Tobago. However, what we must do as a national community is not only look to the addition of hospital bed and hospital spaces and more ambulances, but if we are to beat back this virus, we must get our vaccination rates in both islands up. And that is a plea that I would like to give from this podium this afternoon, that the addition of more resources is not the end game. The end game has to be more and more vaccinations. Thank you very much, Madam President.
Senator Mark.
Can I proceed?
Yeah. Senator Mark.
Question number 39 to the Honourable Minister of Health.
Thank you. The The Ministry of Health, as part of our standard reporting, uses a 7-day rolling average as an indicator of the COVID-19 caseload, as it gives a more accurate reflection over a period of time. In this light, whilst individual days may reach 1,000 as predicted and has happened recently, the rolling monthly average of COVID-19 cases for each of the following months from September to December is as follows. September 2021, 195. October 2021, 214. November 2021, 468. And December 2021, 621. It never reached 1,000. In this regard, the following measures were implemented to reduce the COVID-19 cases per day. Continuous reinforcement of adherence to public health regulations, inclusive of mask wearing, restrictions of gatherings, and washing of hands. 2, ongoing testing, contact tracing, self-isolation, and quarantine at private and public health facilities of infected and exposed individuals. 3, a robust communication program for the uptake of vaccines to save lives and offer the best protection against the COVID-19 virus. All these initiatives are validated based on surveys conducted and reports that provide sound technical evidence from key organizations such as CARPHA, ParlView, and UE. 4, continuous education efforts by the regional health authorities and the private sector to target both individuals and businesses as to the benefits of the COVID-19 vaccines. And 4, the reliance on new spokespersons and opinion leaders outside the Ministry of Health to encourage persons to be vaccinated based on the ease of access and availability. Thank you very much, Madam President.
Senator Mark.
Madam President, can the Honourable Minister indicate in the government's attempts to attract new spokesperson to at least seek to educate and convince citizens to accept the vaccines in the interest of their health? Can the minister indicate how successful the government has been in this particular endeavor?
Minister.
So I think the best way to answer that is to give figures. Evidence speaks for itself. Even though in December you had a rolling 7-day average of 621, and for January to date, it is in the 600s. You know what has gone down? Hospital occupancy. From December 27th to 25th January, on December 27th, you had 543 persons in hospital. 1 month later, because of the success of using new spokespersons and vaccinating 685,376 persons, we have had a decrease in hospitals, persons lying on beds, from 543 to 421. So 122 less persons are in our hospitals. So that is not only clinical evidence, but data that shows clearly that the government's policy of using new spokespersons and vaccines is, in fact, the way to go. As I just indicated for Tobago, the same thing applies to Trinidad. And could you imagine, Madam President, if more and more persons got vaccinated? This number, which decreased from 563 in hospitals on December 27th to the 25th of January, 421, a decrease of 122. If more persons believed what we are saying about the usefulness of vaccinations, much less persons can be in our hospital system. So I use this opportunity again to urge the unvaccinated to do the right thing, listen to the science, and get vaccinated.
Senator Mark.
Madam President, having regard to what the Honourable Minister has said in terms of the number of persons who have not been hospitalized, or there has been a reduction in the hospitalization numbers, can the Minister explain why the number of cases have increased during the said period, whilst the number of persons hospitalized has been reduced. Can the Minister explain to us?
Minister.
So as we said from the very onset of the vaccination program, and this is a misconception, and I thank you for raising it. It gives me an opportunity. Vaccines does not prevent you from possibly becoming infected. And we said that from day one. But we held out 3 promises for vaccinations. 1, it will significantly reduce your chance of being infected. 2, it will significantly reduce your chance of being hospitalized, which you have the evidence here for. And 3, it will significantly reduce your chance of getting into an ICU, HDU setting. That is the promise of vaccinations. It will help break the chain of transmission. It would not prevent all transmission. And we have said that clearly. So again, I produce the evidence that 685,376 persons are vaccinated, 49% of the population. And the number of persons needing hospital care has gone down significantly. That is the promise of vaccinations. And I urge that other 51% of the population who is not vaccinated to listen to the science, follow your mind, and get vaccinated. The evidence I have produced is there.
Senator Mark?
No, I'm cool. I just want to follow up on something.
Sure.
I'm through with the questions. Madam President, in light of the fact that the 2 written questions were due since the 30th of December, thereabout, if I'm correct rather, I would like to ask your good self to invoke Standing Order 27, subsection 16, or Standing Order 16, Standing Order 27, Madam President, subsection 16, to address this outstanding matter that we have before us. That is question number 45 for written answer, and question number 46, which were both due, Madam President, on the 30th of December, 2021.
So in respect of questions number 45 and 46, Standing Order 2716 is hereby invoked. Standing Order 27, sub 15, has been invoked. Senator Roberts.
Madam President, I see there's a problem with this microphone on this side. It's popping and very distracting. Maybe we could allow everyone to use that side until they rectify, please.
Senator Roberts, I'll be addressing that very shortly. Thank you.
Public business, private members' business, motions.
Senator Mark. Honourable Senators, I just want to indicate there is a problem with the audio, and it is being addressed as we speak, so that I will be monitoring the situation. Senator Mark.
Thank you. Madam Chair, I think I'm missing my... Thank you, Madam President. Madam President, I beg to move the following motion standing in my name. Whereas it is provided by Section 123 of the Constitution that the Commissioner and Deputy Commissioner of Police be selected by criteria and procedure prescribed by order of the President, subject to negative resolution of Parliament. And whereas the Commissioner of Police and Deputy Commissioner of Police selection process number 2 order 2021, and the Commissioner of Police and Deputy Commissioner of Police selection order number 2 amendment order 2021 were published on November the 25th and 26th, 2021 by legal notices number 277 and 278 respectively, and whereas the orders, among other things, significantly diminish the role of the Police Service Commission, be it resolved that the Commissioner of Police and Deputy Commissioner of Police selection process number 2 order 2021 and the Commissioner of Police and Deputy Commissioner of Police selection process number 2 amendment order 2021 be annulled. Madam President, we are here today not for the first time to bring to your attention and through you to the people of this nation another incursion, if not erosion, into the independence and autonomous institution under our Constitution, known as the Police Service Commission by this government. Madam President, in its quest for conquest of institutions of state, even in the face of several court judgments, including the High Court, the Court of Appeal, and the Privy Council, there appears to be a relentless assault on these institutions, particularly the Police Service Institution, Police Service Commission rather, by this administration, aimed at influencing, interfering, gerrymandering, and manipulating the role, powers, and functions of the Police Service Commission that persists. Madam President, it appears that this government knows no bounds. Madam President, before I get into these two notices, I want to refresh your memory and, through you, Senator's memory. Madam President, it was in 2005, 2006, that a UNC-PNM bipartisan approach was taken to amend sections of the Constitution in order to bring about a modernization of our police service, and to do so through improved management of its operations, all aimed at ensuring and improving the safety and security of our citizens. Madam President, I remember the Honorable then Leader of the Opposition, Basdio Pandey, indicating, and it is in the Hansard record, that when we are dealing with lawmaking, and what we have before us, Madam President, is subsidiary, or what is called secondary legislation. And the former Leader of the Opposition, former Prime Minister, Mr. Basdio Pandey, indicated that there were certain principles that we should use to guide us when we are dealing with lawmaking. Three fundamental principles were outlined. One, laws must not lead to an abuse of power. Secondly, laws should never lead to the introduction of violence into the political system. And thirdly, laws should in no way facilitate discrimination of any kind, but rather should promote meritocracy. Madam President, I raise these to put into some perspective what we are about to address. Madam President, it was Lord Acton who once remarked, "Power corrupts, and absolute power corrupts absolutely." Madam President, it was on the 25th of November 2021 that we were alerted through the Gazette of a legal notice issued by the government. It is legal notice number 177. And in that 4-page document, Madam President, the government, acting under 123(2) of our Constitution, and Madam President, I will be making reference to our Constitution from time to time so that colleagues who are following this debate will be able to appreciate exactly where we are coming from. Madam President, you will see under Section 123(2) of our Constitution that it states, and I quote, "The Police Service Commission shall nominate persons for appointment to the offices specified in subsection 1A and section 22(1) of the Police Service Act in accordance with, Madam President, the criteria and procedure prescribed by order of the President, subject to negative resolution." Madam President, when the word President is used in 123(2), it does not refer to Her Excellency. It refers to the Cabinet. So when you go to this particular order that we have before us, Madam President, you will see at the end of this notice the document being signed by one C. Henley, Secretary to the Cabinet. So it is the executive arm of the state, through the Cabinet, that is responsible for invoking the criteria and procedure involved in this selection and the selection criteria and procedure as it relates to the nomination of a commissioner of police and a deputy commissioner of police. Madam President, you also have to take into account that these orders were issued against or on the heels of Justice Nadia Kangalu's judgment, which was issued on the 14th of October 2021. In that judgment, Madam President, the judge deemed the order of 2009, order number 2, I think 103 illegal notice, was ultra vires the Constitution, illegal, unlawful, and unconstitutional. And this order that came in the legal notice 277 went a bit further, Madam President, and annulled not only that order of 2009, but it also revoked, Madam President, legal notice 183, which was piloted in June of 2021 by the Honorable Attorney General, who defended that particular legal notice when I brought a motion to annul same. My motion was defeated, and the Attorney General stood his ground, saying that this was proper. The very Attorney General's government in this 277 has now revoked completely not only paragraph 4, but every section of that legal notice 183. So, Madam President, when we look at the first legal notice of 277, it appears on the surface to be reasonably consistent with the judgment issued by the then by Justice Nadia Kangalu on October the 14th, I think, 2021. However, Madam President, this document that is legal notice number 277, dealt not only with the appointment of a substantive police commissioner and his 3 deputies, that is, Deputy Commissioner of Police, but it also, Madam President, dealt with how the Police Service Commission should go about addressing acting appointments in the absence, either on illness or the person being out of the country, or a vacancy has arisen in terms of the Commissioner of Police office, as well as the absence on the grounds of illness or somebody being out of the country, who should act for what is called Deputy Commissioners of Police, Madam President. So legal notice number 277 address those 2 critical areas, substantive appointments as well as acting appointment. Madam President, may I again reference you to our Constitution, and that is question our Constitution 123.1. 123.1 subsection A. It reads, the Police Service Commission shall have the power to appoint persons to hold or act in the office of Commissioner and Deputy Commissioner of Police. So the order is deriving its power and strength from 123.2 of our Constitution. So, Madam President, when we looked at legal notice number 277, the government appeared to be going down a path that appeared on the surface to be consistent with Justice Nadia Kangalu's judgment and decision, decisions to revoke legal notice 2 of 2009, number 2, 103, I think, Madam President, as well as making paragraph 4 of legal notice number 183 of June of 2021 superfluous. But the government has gone a step further to revoke that entire legal notice 183. So, Madam President, if you go to page 1 of legal notice 277, you will see where an attempt is made by the Cabinet, not the Police Service Commission. I want to make it very clear. These criteria that is before us today were not drawn up by the Police Service Commission. They were drawn up, Madam President, by the Cabinet led by the Prime Minister. So the Prime Minister and his Cabinet decided for the Police Service Commission, in accordance with 123(2) of our Constitution, how the Police Service Commission, which is supposedly an independent institution under our Constitution, how they should go about selecting, Madam President, a police commissioner and his deputies. And Madam President, as we go to page 3 of this legal notice, you will see under subsection, let's say section 4, or you don't go to clause 4, Madam President, go to subsection 2, and you will see, Madam President, and I'll quote, for the purposes of acting appointments to the office of Commissioner of Police, the Commission, that is the Police Service Commission, shall establish and maintain an order of merit list, which shall list in descending order of seniority the officers who are A, holding or acting in the office of Deputy Commissioner of Police or Assistant Commissioner of Police, and also possess the qualifications and experience required for appointment to the office of Commissioner of Police. So, Madam President, in clause 4, subsection 2, the government in its notice indicated that if you are to act for a police commissioner or act for a deputy police commissioner, a merit list shall be established by the commission in descending order of seniority. Madam President, when you come to the substantive appointment of a commissioner of police, on page 2 of the same legal notice, it states, and I quote, in E, the commission shall take into account all ALL information on the candidates and thereafter establish an order of merit list, indicating the highest graded candidate followed by other candidates in descending order of merit. Madam President, because of legal uncertainty in this particular provision, I have concluded that when this legal notice referred to all information of the candidate, I am positing it would incorporate seniority in this particular exercise. So my argument, Madam President, is that seniority is included when you are determining the substantive holder or the appointment of the Commissioner of Police. That is recorded in section 3E, 1E. And when you go to 4, subsection 2, the government went a step further, that is the executive, and they went on, Madam President, to outline in detail, Madam President, that everything that is being done by the Commission should be done on the basis of an order of seniority. It appeared in 4.2 of this legal notice. It appeared in 4.2b of this legal notice when it says that the Commission shall select the most senior officer. It was also reiterated in clause 4, subsection 4, again the most senior officer. And then when you go, Madam President, to 5, subsection 2, it is repeated again in descending order of seniority. And when you go down, Madam President, to 5.2b, it is repeated there. It is repeated in 4. And Madam President, we felt at that time it appears that the government was adhering to the law and to the Constitution. But Madam President, within less than 24 hours was our Attorney General, who I missed deeply last week when he was not here, whilst our distinguished Attorney General was conducting state business in the United Kingdom, the acting Attorney General, Stuart Young, issued or was responsible for guiding the cabinet in issuing ultimately these 2 legal notices, 277. And Madam President, within 24 hours of notice, legal notice 277 being issued, talking about seniority in descending order, the government of Trinidad and Tobago, in the absence of the Attorney General, amended, Madam President, in less than 24 hours and issued a new legal notice number 278. And Madam President, in legal notice 278, when we go to clause 3, Madam President, hear how it reads. In clause 4 of the order, Madam President, if you go to clause 4 of the order, here is what 278 is saying to this order, 277. In subclause 2, the government says delete the words in descending order of seniority. So in 277, Madam President, we have descending order of seniority. In 278, the government moves another legal notice and they deleted seniority in 278. Madam President, it did not stop at 3 as it relates to clause 4. It went to clause 4b. Wherever the most senior officer on the order of merit list appears, delete that, gut that, remove that. When you go to subclause 4, the most senior officer on, remove that, delete that. And Madam President, it went to clause 5, and in descending order of seniority, delete. In subclause 3, the words, the most senior officer on the order of merit list, be deleted, Madam President, and so on and so on. And when we go to what is called clause 4C, Madam President, the most senior officer on be deleted. So, Madam President, we became very concerned. Why would the executive, the government, seek to amend an order that was issued 24 hours ago, where the government recognized the importance of seniority as a principle for elevation in the police service? Why would the government all of a sudden, Madam President, delete that in this new legal notice 278? So, Madam President, I became, and the opposition became, concerned about this. Why would the government do such a thing, Madam President? Because this is a very serious business, Madam President. You are talking about, Madam President, the police service, and you are talking about the Commissioner of Police. Madam President, I do not want to burden you with refreshing your memory, but I want to let you know that there has been a pattern of conduct on the part of this government in the past and now in the present, to influence, interfere, manipulate, gerrymander the whole process as it relates to the selection and the appointment of a commissioner of police, and I dare say, Madam President, a deputy commissioner of police. These matters had to go to court when we discovered what the government was attempting. And Madam President, I have two judgments before me. Justice Rajkumar in Haridat Maharaj versus the Attorney General. There is the Balboza case as well. There is the Justice Nadia Kangaloo case. And the most famous cases of all is the Endel Thomas versus the Attorney General in 1982. That is the classical case of interference which began then, Madam President. So, Madam President, you would recall when an independent service commission, police service commission, recommended a police officer to become police commissioner, he was number one on the order of merit list. The list came to the government in the House of Representatives. And Madam President, the government rejected that individual, a fellow called Diochan, I think it's Dula Chan. I think it's, yes. Dula Chan was rejected by the government. And Madam President, a process the government engaged in order to justify why this gentleman could not become Commissioner of Police. Thereafter, Madam President, you recall that Stephen Williams was rejected in that exercise later, subsequent. And then you had a new commissioner being appointed. The new commissioner has come into being. Now the new commissioner has left. That is the last police commissioner. And now you have another one acting in his stead. Madam President, so there is a pattern of conduct on the part of this administration to attempt, Madam President, to do whatever they can to influence through legalisms the independent, constitutionally entrenched, quasi-judicial, autonomous police service commission so that they can go in a direction that the government wishes it to go. So, Madam President, here we are. The government has removed seniority. Madam President, but what is the implications of that? If you are going to remove seniority on the basis of elevation for someone to act in either the office of Commissioner of Police or Deputy Commissioner of Police, Madam President, what is going to guide the Police Service Commission in determining elevation? If on the basis of equality of qualifications, the basis of experience between two individuals who have the rank of Deputy Commissioner of Police, but one of them, Madam President, is more senior to the other. The most senior one, according to the Constitution, supposed to be given the position or the green light to act as Commissioner of Police. But now, Madam President, in this legal notice 278, the government has deleted and gutted seniority. What is the Police Service Commission to do? Who is the Police Service Commission to appoint, Madam President, to act in the office of Commissioner of Police? Or in the event that the Deputy Commissioner of Police is out of the country, who is going to be acting for that Deputy Commissioner of Police? Madam President, this approach by the government is a recipe for confusion and chaos in the police service. That is a dangerous, disturbing troubling and concerning matter that we need to address. Madam President, if I am a police officer and I am looking in the police service, I'm looking at the police service as a career path, and I am operating in accordance with the Police Service Act, I am not allowing any politician to manipulate me. I am working in accordance with the law. My loyalty is to the law. My loyalty is to the Constitution. My loyalty is to the people, not to no prime minister, not to no party. And Madam President, I have a chance to be promoted, to act as Commissioner of Police. You know what the government is saying to Trinidad and Tobago and that police officer? You see, your years of service in the police service doesn't matter any longer. I can take a junior officer who has less service than you in the police service. And because of these criteria that I have instructed the Police Service Commission to follow, Madam President, what it means, Madam President, is that myself, as a career police officer, will be bypassed, and a junior police officer will take my stead, because that junior police officer may be, Madam President, I'm not saying is, may be that police officer that is going to take his place and act as Commissioner of Police. He has a party card. He is loyal, Madam President, to the ruling party, whichever ruling party, be the UNC, be the PNM. And that person is given the green light, Madam President, to become acting Commissioner of Police. Madam President, that is a recipe for chaos. You are going to demotivate the police and the police service. We must operate by rules, Madam President. We cannot operate vike. And what the government is doing, Madam President, in this particular legal notice 278 is operating by vike. And they're doing whatever they want to achieve, Madam President. Never forget, they are trying to achieve a particular objective. And the objective is to select and to get the police commission to appoint a police commissioner of their liking, so that the police commissioner will be able to dance to the drumbeat of the prime minister, whichever the prime minister, whoever is a prime minister, whichever party is in power. Madam President, it doesn't matter. We are dealing with principles here, Madam President, not party. And whoever is in power as party, we must obey the Constitution. And the police commissioner is supposed to be independent of any political party and any prime minister. And that is the danger, Madam President, of this annulment to 277 through 278. Madam President, I have looked very carefully as a Bush lawyer. I have looked very carefully at our Constitution. And Madam President, when I look at our Constitution, I want to share with you, and if you can follow me, Madam President, I want you to go to what is called Section 129.1 of our Constitution. 129.1 of our Constitution says, and I read, subject to subsection 3, a service commission, which includes a police service commission, may, with the consent of the Prime Minister, by regulation or otherwise, regulate its own procedure, including the procedure for consultation. So, Madam President, 129.1 says, the Police Service Commission, with the consent of the Prime Minister, shall make their own regulations. Madam President, 129.1. Madam President, I go to what is called the Police Service Commission regulations. Follow me very carefully, Madam President. We go to the Police Service Commission regulations. These regulations are appended to the Constitution. These regulations are part of the Constitution. These regulations came into being as a result of 129.1 of our Constitution. I am positing to you, Madam President, and to my honorable colleagues in this honorable Senate, and to the people of Trinidad and Tobago, that no subsidiary legislation, no secondary legislation can trump our Constitution. I want to repeat, Madam President, no subsidiary legislation, which is what the legal notices are, can trump the supreme law of the land, which is the Constitution of the Republic of Trinidad and Tobago. And any law that does that, in accordance with Part 2 of our Constitution, is ultra vires, it is void, it is illegal, it is unconstitutional, and it should be annulled and withdrawn today. Madam President, let me edify this honorable House. Madam President, go to the Police Service Regulations, which is constitutionally protected under 129.1 of our Constitution. And hear what it says, Madam President. Under Article 24.1 and 2, I read, Madam President, where an acting appointment falls to be made otherwise than as a prelude to a substantive appointment, the police officer appointed shall, Madam President, as a general rule, be the senior police officer eligible for such acting appointment. May I reread this, Madam President? What this is saying, that outside of a substantive appointment to the position of Commissioner of Police, any acting appointment falling under the jurisdiction of the Police Service Commission, there is a general rule that it be done on the basis of the most senior police officer eligible for such acting appointment. And it says in B, assume and discharge the duties and responsibilities of the office to which he's appointed to act. Madam President, it goes on in subsection 2 of 24 to state, and I quote, in making an acting appointment under subregulation 1, the Commission shall examine whether the exigency of the service would best be served by appointing a police officer next in line of seniority from another division to act when there's a police officer in the same division who is capable of performing the duties of the higher grade, and in such examination, the question of additional government expenditure for traveling and subsistence allowances and any other expenditure shall be borne in mind. Madam President, the research has led the opposition to this particular provision under the police service regulations. And the regulation 24 makes it, as the former Prime Minister, not the Attorney General, I see people, some people giving paternity to this expression, to the Attorney General. It was the former Prime Minister, Patrick Manning, who talked about pellucidly. He always kept saying, I want to make it pellucidly clear. Patrick Manning. Well, I want to borrow from him today. I would like, on behalf of the opposition, to make it pellucidly clear, Madam President, that Section 24, or you could call it Article 24.1 and Sub 2 of the Police Service Commission regulations makes it abundantly clear, Madam President.
Senator Mark, you have 5 more minutes.
Yes, thank you, Madam President. Makes it abundantly clear that the Police Service Commission has its own regulation, and the Police Service Commission determines, when you deal with acting appointments, that a general rule shall be seniority. So no executive can bring subsidiary legislation to trump the Constitution and to trump, Madam President, what is called subsidiary legislation, or to trump the Constitution. So that is our position, Madam President. Madam President, if you go to the public service regulations and you look at what is called the prisons and the police, the fire rather, under the public service regulations, if you go to Article 26 of that, you go to 1, you have the same provision, a general rule for the senior officer in the ministry. So wherever you turn, you are seeing the principles of selection for acting appointment must include seniority. So the government never indicated to Trinidad and Tobago why they excised this provision. It's against that background that we have brought this measure, and we call on the government to annul and withdraw this matter. Madam President, let me say in closing, it is for the commission, that is the Police Service Commission, and the Police Commission alone, to appoint not only to hold office, but to act in offices, police officers, not the government, not the executive. And that is well established in the Barbosa judgment, Madam President. You also have to look at what took place in the Rajkumar judgment, Madam President. Therefore, it appears that the government of Trinidad and Tobago is laboring under the misapprehension as to who is truly responsible for appointing, promoting, and providing persons the opportunity to act in positions. And the executive seems to be on a course to manipulate and try to direct the Police Service Commission in doing its work. Madam President, if you go to paragraph 76 of the judgment in Rajkumar, it is very clear on the role of the Police Service Commission. And therefore, the principle of political insulation must be emphasized, and that is what we are promoting and emphasizing in our motion concerning Orders 277 and 278. In closing, Madam President, I want to ask the Attorney General quite frontally, since the judgment of Justice Nadia Kangaloo, Madam President, to revoke and to make illegal and unconstitutional Legal Notice 209-103 number 2 order, what is to happen with all those illegal decisions taken between the period 2009 to October 14, 2021? Is the government going to bring legislation to retroactively validate those illegal decisions? Or is the government going to leave it hanging in the atmosphere so somebody might have to take legal action for any action that might have been taken between the period 2009 and 2021. So, Madam President, these are some of our concerns as it surrounds this particular matter. We believe that the government is on a course, Madam President, to attempt to further its ambition to manipulate. And in closing, Madam President, the AG must also let us know what has happened to Andre Norton, whose notification came here, Madam President, and it never went forward. Let him clear the air on that. Madam President, with these few words on this very important matter, I would like to beg to move at this time. Thank you very much, Madam President.
Someone has to second the motion.
I beg to second the motion and reserve the right to speak at a later stage.
The motion has been seconded by Senator John. Honourable Senators, I will now propose the question for debate. The question is, whereas it is provided by Section 1232 of the Constitution that the Commissioner and Deputy Commissioner of Police be selected by criteria and procedure prescribed by order of the President, subject to negative resolution of Parliament. And whereas the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2 Order 2021 and the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2 Amendment Order 2021 were published on November the 25th and 26th, 2021 by legal notices number 277 and 278 respectively. And whereas the orders, among other things, significantly diminish the role of the Police Service Commission, be it resolved that the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2 Order 2021 and the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2 Amendment Order 2021 be annulled. Attorney General.
Thank you. Thank you, Madam President. May I just inquire the speaking time in this House, please?
You have 40 minutes.
Thank you very much. Madam President, I must say that Senator Mark's contribution today was very measured, and I certainly do relish the opportunity to join this debate because I think it is important that the Hansard reflects answers to the many questions put by Senator Mark. It's not often that I say what I just said, but I will tell you why I have said that this is a measured purpose. The motion before us is properly before us pursuant to the Interpretation Act. It's pursuant to Section 75(7) of the Interpretation Act, where negativing a subsidiary piece of law is within the purpose of our Parliament. And therefore, with these orders having been published as they were, we are properly here to consider whether the Parliament as a whole ought to consider that this subsidiary legislation is in some way tripping the Constitution of the Republic of Trinidad and Tobago. Now, it would be proper to revoke orders or negative them, as we say in the Interpretation Act, if the orders were offensive to the Constitution. That's the test that we're here for. What inside of these two orders, that is, those orders published by Legal Notice number 277 and Legal Notice 278, are repulsive to the Constitution of the Republic of Trinidad and Tobago. The Constitution of the Republic of Trinidad and Tobago that we are treating with, the sections of the Constitution, the material section, Senator Mark alluded to them, it's Section 123 of the Constitution, where we deal with the power of the Police Service Commission to embark upon a process prescribed by the Constitution to select a Commissioner of Police or a Deputy Commissioner of Police or an acting Commissioner of Police or an acting Deputy Commissioner of Police. That's what Section 123 does. The rule of law in interpreting the Police Service Commission's role and function, and therefore how we are to address these two orders that we're looking at, is to see what inside of these orders may or may not be repulsive to the Constitution. So let's start immediately by looking at the orders. Legal notice number 277 is the order made under the Constitution of the Republic of Trinidad and Tobago. It's made by the President pursuant to Section 123(2) of the Constitution. And the first paragraph, 1, is the name of the order or citation. The second paragraph is the interpretation. This order, commission, means the Police Service Commission established under Section 122. And then you have paragraph 3 and then paragraph 4. Paragraph 3 is the selection process that we must look at when we are looking for the offices of Commissioner of Police and Deputy Commissioner of Police. So paragraph 3 sets out that the Commission, and only the Commission, shall conduct a recruitment process including inviting applications for the positions, advertising the vacancy, it says in 2 daily newspapers, on at least 3 days within a period of 7 days. The Commission, from those applications received, shall select the most suitable candidates for the assessment process. The Commission shall ensure that the candidates are subject to security vetting and recent professional vetting. The Commission shall conduct the assessment referred to in paragraph B and shall have regard to qualification and experience of the candidate, medical examination report, security and professional vetting report. The Commission must then take into account all information on the candidates and thereafter establish an order of merit list indicating the highest graded candidate and then a descending order on the merit list. The Commission shall select the highest graded candidate, submit that candidate's name to the President in accordance with the procedure set out in 123. What does 123 say? You need to bring the list to the Parliament, the nominee, and then there must be a debate in the House of Representatives, and that candidate must be approved in the full glare of the Parliament and therefore the nation. It then goes on to say what happens when the order of merit list is exhausted and how you proceed. So let's look at paragraph 3 within the law. Number 1, Senator Mark is correct. The leading dicta coming from the Endell Thomas case is what guides us. In the Endell Thomas case, of course, we're treating with the very clear principle of making sure that we are protecting the process from political interference. That's the very reason why Section 123 of the Constitution was amended in 2006. Prior to the amendment in 2006, the Prime Minister enjoyed a veto in respect of the appointment of a Commissioner of Police or Deputy Commissioner of Police. But in Endell Thomas, it's true to say that the whole purpose of Chapter 7 of the Constitution, and I'm quoting from the Endell Thomas case, which bears the rubric, the public service is to insulate members of the civil service, the teaching service, and the police service of Trinidad and Tobago from political influence exercised upon them directly by the government of the day. The means adopted for doing this was to vest in autonomous commissions, to the exclusion of any other person or authority, power to make appointments to the relevant service, promotions and transfers within the service, and power to remove and exercise disciplinary control over members of the service. Fortunately for us, Endell Thomas establishing that, we have had the benefit of 2 judgments of our court. The first is in the case of the Haridat Maraj judgment, which, as we all well know, was born as a result of a constitutional challenge to strike down the 2015 order, which we as a parliament made. The opposition, led by the leader of the opposition, approached the court to strike out the entire 2015 order on the ground that it was ultra vires or offensive to the Constitution. The court did not agree with the fulsome submissions. The court upheld the constitutionality of the 2015 order. The court did declare that certain sections of the order were ultra vires. Number one, the direction that the minister start the process by asking the Police Service Commission to do what it should. That was removed by way of the judge amending the law. Number two, the use of the Central Tenders Board Section 20A provision was struck out. Those are the only two substantive reasons that fell in the Haridat Maraj case. In that case, it is important to note that the court upheld the constitutionality of the 2015 order. And why is that relevant? Because the 2015 order finds itself in large part in the paragraph 3 of legal notice number 277. If you do a comparison of the wording between paragraph 3 of the 277 order, which Senator Mark says we ought to strike down today by negativing it, and you compare the Haridat Maraj judgment, you will note that there has been only a simplification and no deviation away from that wording, so therefore we are within constitutionality. Why do I say that? Because of the second judgment. The second judgment is the Ravi Balgobin Maraj case. Our colleague Senator Lutchmedial participated in that case and would know, as did I participate as Attorney General, as the defendant in that matter, the Ravi Balgobin Maraj case, in the challenge in the court, that legal notice passed by this government and upheld by this Senate was not challenged on the basis of constitutionality. In fact, the claimant, Ravi Balgobin Maraj, went to the High Court and said, this legal notice is perfectly correct. They asked for the appointment of Commissioner Griffith to be revoked on the basis that essentially there had been a failure by the Police Service Commission and the Office of the President to have an affirmative resolution of the appointment. They did not challenge the constitutionality of Legal Notice 183. In fact, that is very relevant to this debate because paragraph 3 of Legal Notice number 277 repeats the substance of the Legal Notice 183. That's what it does. So, if we look to Senator Mark's invitation that we are to annul, negative, Legal Notice number 277, paragraph 1 is in perfect order, paragraph 2 is in perfect order, paragraph 3 has been upheld in effect by the judgment in Haridat Maraj, Mr. Justice Peter Rajkumar as he then was, and secondly, by the dicta confirming the constitutionality in the Ravi Balgobin Maraj case, where Madam Justice Nadia Kangaloo upheld the constitutionality of Legal Notice 183, which is the legal notice that finds itself in paragraph 3 of this order. The next paragraph to look at is paragraph 4 of this order. Paragraph 4 of this order says, notwithstanding clause 3, the selection process for acting appointments to the Office of Commissioner of Police shall be as provided in this clause. And 277, this legal notice, went on to establish, for the purpose of acting appointments to the Office of Commissioner of Police, the Commission shall establish and maintain an order of merit list, which shall list in descending order of seniority the officers who are holding or acting in the office of Deputy Commissioner of Police or Assistant Commissioner of Police, and who possess the qualifications and experience required for the appointment of Office of Commissioner of Police. In the circumstances where the Commissioner is or is likely to be absent from Trinidad and Tobago, on vacation leave, or unable by reason of illness or other reason to perform the functions, the Office of Commissioner of Police is likely to become vacant. The Commission shall select the most senior officer on the order of merit list and submit that officer's name to the President in accordance with the procedure set out in 123 of the Constitution. Where in relation to subclause 3, the House of Representatives does not approve the most senior officer on the order of merit list, etc., you go ahead. Now, the very next legal notice that appears is 178. And 178 amended what I have just read out in 277 by removing references to the most senior officer. And let me explain why that was done. It is a fact that the Acting Attorney General, Minister Young...
Senator Thompson-Ahye, you are asking the Attorney General to give way? No, I think he has to consent first, Attorney General.
Very little time, so could the Honourable Senator ask a quick question?
You said 178, and I'm asking you, do you in fact mean 278?
I thank you, 278.
Thank
So
you.
after 277, 278. The 278 order removes the reference to senior officers, and let me explain why. Minister Young, acting as Attorney General, did take the note to Cabinet in my absence. Upon my return, the very night that this was published, Minister Young and I had a conversation, and I referred him to advice that the Office of the Attorney General has, that this particular reference to seniority in senior counsel's considered opinion, counsel advising us as he has, the reference to seniority would constitute an unfair fetter or undue fetter upon the discretion of the Police Service Commission. Let me explain why. The Haridat Maraj case established, as has many cases, Cooper and Barbosa, etc., that there must be an absolute discretion in the hands of the Police Service Commission. If we look to the 2009 order, which paragraph 4 is intended to put into life, you must remember in the Ravi Balgobin Maraj case, the claimant, via his attorneys, sought to rely upon the 2009 order as being constitutional. It's in paragraph 40 of their fixed date claim. As Attorney General, I accepted the submissions of the claimant that the appointment of Griffith should have come to the Parliament for affirmative resolution. The judge starts her judgment by saying, quite remarkably, the Attorney General agrees with the claimant. But I drew to the court's attention that the 2009 order was, if we look at the law again, if you look at the 2009 order, it was ultra vires the Constitution, because it granted to the Police Service Commission the ability to appoint a Commissioner of Police to act without reference to the Parliament, and therefore in defiance of Section 123 of the Constitution. I was compelled, with that issue being raised, to consider it. Now, is this a case where everybody agreed? No. The Police Service Commission, via very eminent counsel, Mr. Russell Martineau, did not agree with that position, held the view that acting appointments are different from substantive appointments, held the view that it would be obscene to ask somebody to move the Parliament to be appointed for one day if the Commissioner was out of the country. But the point is, the case that came before Madam Justice Kangaloo raised for the first time the procedure for an acting appointment. And the 2009 order, which paragraph 4 of this legal notice as amended, legal notice number 277, paragraph 4 deals with what was in legal notice 103 of 2009, which was struck out by Justice Kangaloo because she agreed with the Attorney General's submissions that that legal notice number 103 of 2009, which allowed the Police Service Commission to appoint a Commissioner of Police to act without reference to the Parliament, that was ultra vires. Now, Senator Mark asked a very important question. So for 16 years, 15 years, we had the position of the 2006 amendment to the Constitution. From 2009, successive governments, a PNM government, a UNC government, a PNM government, saw hundreds of acting appointments made pursuant to legal notice number 103 of 2009. Those appointments are in law deemed to be valid, notwithstanding the strikeout of the notice by way of operation of law, and therefore the advice is that there is no need to bring validating legislation to cure those facilities, because the law will take care of the validity of the actions taken. It is important to note that Ravi Balgobin Maharaj, that case, in the arguments in that case, as is clear in the fixed date claim form, counsel and senior counsel for Ravi Balgobin Maharaj did not share the view that legal notice number 103 of 2009 was unlawful, but the court obviously and correctly agreed that it was. So paragraph 4 treats with the replacement of legal notice from 2009. It says that you must allow ACPs, Assistant Commissioners of Police, and DCPs, Deputy Commissioners of Police, the ability to act in the Commissioner of Police, provided that they meet the criterion which is set out by way of legal notices that are in effect, that you have a degree, etc., it's prescribed, and that it is solely for the Police Service Commission to consider who is the most appropriate person to act from that pool of people. Why is the reference to the regulations of seniority not appropriate? Number one, if we were to direct in law for the first time that you had to go by way of seniority, the 2009 order does not provide for seniority. The 2009 order says the Commission may, as it thinks fit, appoint to act in the office of Commissioner of Police a person holding or acting in the office of Deputy Commissioner of Police. Where the Commissioner is absent, the office is vacant. There is no reference to seniority here. If we were to include a reference to seniority, as Legal Notice 277 did, we would be fettering the discretion of the Police Service Commission. The Haridat Maharaj case, the Ravi Balgobin Maharaj case, the Cooper and Balbosa case, and umpteen cases, the Endell Thomas case, all set out that the discretion of the Police Service Commission is to be unfettered. If we were to adopt the fettering of the Police Service Commission's discretion by mandating that it must appoint the most senior person, we would be ultra vires the decisions of the court, of the Constitution, and the decisions of the court. It's as simple as that. The reference to the police service regulations having been made by Senator Mark, as he correctly put onto the record, where there is reference to seniority, Senator Mark is correct. Those regulations, which are subsidiary to the legislation and certainly inferior to the constitutional provisions of Section 123, they can stand apart from itself. But these legal notices, 277 and 278, spring from the Constitution itself. And these legal notices cannot incorporate a fetter upon the discretion of the Police Service Commission by mandating that the most senior person must be appointed by the Commission. After all, isn't it logical that there could arise a situation where there are multiple assistant commissioners of police, multiple deputy commissioners of police, and that the best person ought to be appointed for the job? That's the role and functionality of the Police Service Commission. Not to simply pick the person who has been in the job the longest. The person who has been in the job the longest may not be the best person for the job. And therefore, to accept the submission that these legal notices are nefarious, are improper, are ultra vires, is to accept a submission which must be rejected most respectfully. I am grateful to Senator Mark for raising this issue and the many sub-issues that have flowed from his contribution, because it allows for ventilation. This is the reason that Section 77 of the Interpretation Act exists. Why a motion to negative can be brought, so that there is ventilation. In fact, if you look to the dicta, you will see that it is these kinds of processes, motions such as this, that bring our democracy to life. So I do warmly accept the debate on this occasion, but I must draw the distinction that we ought not to confuse the subsidiary legislation of the regulations, the police service regulations, with these orders which flow from Section 123 of the Constitution, because the purpose of these orders, 277 and 278, are the following. Number one, so that we can harmonize what the law is without having to go and read amendments. Why? Justice Kangaloo, in her wisdom, made a decision which we did not appeal, even though we could have as to part of it. Justice Kangaloo's decision upheld the constitutionality of Legal Notice 183. The Honorable Judge, in quite an unusual ground that's not known to me, certainly, and to attorneys, declared that a certain part of that legal notice was superfluous. That is not a term that is recognized. That was the ground that we could have appealed. But because the judge had effectively amended Legal Notice 183, saying that, look, the last paragraph was not necessary because the body takes care of it, we would have put the Parliament in a difficult position of having to read the notice without it being amended. Secondly, because the court struck down Legal Notice number 103 of 2009, declaring it to be unconstitutional at the request of the Attorney General by the direction of Her Excellency the President to raise the issue in court, we would be in the position where we would have to go and read several pieces of law. So the intention in publishing Legal Notice 277 as amended by 278 is, number one, to have one law available for the public to consume, attorneys to consume, the court to consume. Number two, it is intended to replicate what has been upheld as constitutional. That is paragraph 3 of Legal Notice 277. That has been determined by the case of Haridat Maraj and the Ravi Balgobin Maraj case. That is good law. The last point is in relation to paragraph 4. It is intended to bring to life the method for acting appointments that Legal Notice 103 of 2009 dealt with, but because that was struck down as being unconstitutional, we are compelled, therefore, to put it into the body of the law. Now, honorable senators, it is a fact that the mandatory requirement that acting appointments must be done by way of an affirmative resolution of the House is difficult. In fact, it is obscene in certain circumstances, because it means that if somebody has to act for a day, you have to move the House. What is required, ultimately, would be a constitutional amendment to Section 123 to allow for short-term appointments without moving the Parliament. That will require a constitutional majority. That will require a significant discussion. As yet, we are not in a very warm place where we have had submissions accepted by the opposition, but that is a conversation that will be had, because Section 123 of the Constitution certainly does require an amendment by way of constitutionally supported majority legislation to cause acting appointments to be made in circumstances where it is reasonable, 1 day out, 1 week out, etc. So, Madam President, this is an important debate. I thank the Honourable Senator for raising this issue. The summary submissions are quite clear. This is certainly a position where we understand that the law continues to evolve and to work After all, Legal Notice 103 of 2009 stood for years. Hundreds of acting appointments were made on the back of it. The claimant in that matter, represented by Mr. Ram Logan and Senator Lutchmedial, they, in their fixed date claim form, upheld the constitutionality of Legal Notice 103. It's in paragraph 40 of their fixed date claim form. The court has now ruled that that is not proper. Madam President, that's what our Constitution is there for. It's a living, breathing, working mechanism. That's what our courts are there for, to interpret the law within the separation of powers and due process principles. This is par for the course. In the same way, we expect judgments from the Privy Council shortly on some very important matters. For instance, the Savings Law Clause, Section 6, which the Chandler case will treat with. This is what the law is about. Madam Speaker, Madam President, these legal notices, 277 and 278, are properly intra vires. They are constitutionally in the right place. They simplify the law insofar as they repeat what has already been approved in judgments of our own High Court to be good law. They bring to life the methodology for acting appointments. We cannot include the seniority reference because that will be a fetter on the discretion of the Police Service Commission, making it unconstitutional. It was only upon my return to the country that I was able to address that issue with the Acting Attorney General, who shares the same view that I do, and we immediately corrected it, in fact, overnight upon my arrival. That is how our government works. We sit and we make sure we check all of the angles, and I wish to say to honorable senators that I genuinely believe that we have safe law before us. I thank Senator Mark for raising these issues on the Parliament floor, and I thank you for the opportunity to contribute.
Senator Vieira? No? Senator Thompson-Ahye.
Thank you, Madam President, for this opportunity to speak on the motion brought by Senator Wade Mark to annul two orders, namely Legal Notice 277, the Commissioner of Police and Deputy Commissioner of Police Selection Process No. 2, Order 2021, and Legal Notice 278, the Commissioner of Police and Deputy Commissioner of Police Selection Process No. 2, Amendment Order 2021. Now, these legal notices replace Legal Notice No. 103, the Commissioner of Police and Deputy Commissioner of Police Acting Appointment Selection Process No. 2, Order 2009, and Legal Notice No. 183, the Commissioner of Police and Deputy Commissioner of Police Selection Process Order 2021. The genesis for these legal notices, 103 and 183, being supplanted was their being deemed invalid by Madam Justice Kangaloo in her judgment delivered on October 14, 2021. I return to this judgment subsequently. Madam President, the offices of Commissioner of Police and Deputy Commissioner of Police are extremely important public offices. As such, the office holder should not only be qualified by academic qualifications and requisite experience, but must be guided by the highest principles, highest ethical principles which pertain to all public office holders. And in this regard, I commend for emulation the Nolan Principles created in the UK by Justice Nolan, chaired committee. And these are the 7 principles of public life, namely 1, selflessness, 2, integrity, 3, objectivity, 4, accountability, 5, openness, 6, honesty, and 7, leadership. On another occasion, when we debate another issue, I may expand on these principles. Now, Madam President, I do not think for a moment that there is anyone in our country who would not wish that the best person be appointed to the offices of Commissioner and Deputy Commissioner of Police. What we also require, and deem just as important, is that the correct procedures be followed in the appointment process. We need an effective and efficient police service, one that protects and serves us, not in name only, but in reality, one that makes us feel safe, one that does not cause us to have difficulty in determining who is police and who is thief, who is criminal posing as police and who is not only upholding the law, but is a law-abiding citizen and who engenders in the citizenry trust and confidence. Now, the powers given to the Commissioner of Police are enormous. When we look at Section 123A of the Constitution, we see that the Commissioner of Police shall have the complete power to manage the police service and is required to ensure that the human, financial, and material resources available to the service are used in an efficient and effective manner. The Commissioner of Police shall have the power to appoint persons to hold or act in an office in the police service other than an officer referred to in Section 123(1)A, which is the top positions, including the power to make appointments on promotion and to confirm appointments, to transfer any police officer and remove from office and exercise disciplinary control over police officers other than an officer referred to in Section 123(1)A. So we really have placed in the hands of the Commissioner some onerous functions. What many must be wondering, though, is why over the years this appointment process for a Commissioner of Police and his essential deputy has been so problematic, so characterized by confusion, engendered so much frustration, and occasioned more change than a 24-hour lizard. I do not, as testimony to my view of our country, and indeed of all countries on the importance of the offices of Commissioner and Deputy Commissioner of Police, the drafters of our Constitution created and our Parliament enacted special provisions for appointment to these positions. One would have thought that that would have been the end of the story, as is the case in most jurisdictions, but we are a special country. The Constitution of the Republic of Trinidad and Tobago, under Section 122, creates a Police Service Commission to be appointed by the President after consultation with the Prime Minister and Leader of the Opposition. It confers on the Police Service Commission the power to nominate persons qualified and experienced in disciplines of law, finance, sociology, or management to be appointed as members of the Police Service Commission. This provision guides the President in her selection process. She cannot go outside of these parameters. She must act in accordance with them. This is what the Privy Council opined in a decided case in respect of another service commission and another president referred to earlier by Senator Mark, I believe. The Constitution further provides for the President to issue a notification in respect of each person nominated for appointment. This notification is subject to affirmative resolution of the House of Representatives, and once the House approves the notification, the appointment is made. Under Section 123(1)A of the Constitution, the Police Service Commission is given the power to, among other things, appoint persons to hold or act in the office of Commissioner and Deputy Commissioner of Police. It also empowers the Commission to remove from office and exercise disciplinary control over persons holding or acting in the offices specified above. Under Section 123(2), the Police Service Commission nominates persons for appointment to the offices of Commissioner and Deputy Commissioner in accordance with the criteria and procedure prescribed by order of the President, subject to negative resolution of Parliament. I must emphasize here that the criteria and procedure are not specified in the Constitution. What the Constitution does is require that these must be made by order of the President and be subject to negative resolution. Section 123(3) of the Constitution requires the Police Service Commission to submit to the President a list of names of the persons nominated to the offices of the Commissioner or Deputy Commissioner of Police. Section 123(4) requires the President to issue a notification in respect of each person nominated under subsection 3. This notification is in turn subject to affirmative resolution of the House of Representatives. Now, when I come to section 123(5), I think it is a very important provision, and I wonder somehow if it escaped the mover of the motion, because that section 123(5) stipulates that the Police Service Commission appoints the Commissioner or Deputy Commissioner, but, and I emphasize, only after the House of Representatives approves the notification in respect of the relevant office. So one must ask, where does power lie? The words only after, what do those words mean? Over the years, we've had several orders made by the President under Section 123 of the Constitution. To name a few, we've had legal notice number 103, Commissioner of Police and Deputy Commissioner of Police, acting appointment selection process number 2, Order 2009, which dealt with acting appointments, now revoked. Legal notice number 218, the Commissioner of Police and Deputy Commissioner of Police election process, Order 2015. We've had legal notice 2019, appointment of Commissioner of Police and Deputy Commissioner of Police, qualification and selection criteria, Order 2015. We've had legal notice number 183, the Commissioner of Police and Deputy Commissioner of Police selection process, Order 2021. Legal notice 277, the Commissioner of Police and Deputy Commissioner of Police selection process number 2, Order 2021, which is engaging us today. Legal notice 278, the Commissioner of Police and Deputy Commissioner of Police selection process number 2, Amendment Order 2021. I'm not claiming this is an exhaustive list, but these were some attempts to fulfill the requirements of Section 123(2). Now, some, as the judge's ruling shows, have not been in accordance with the requirements of the law and arose out of a misinterpretation of the law. Some have had to be carefully considered, and really what has happened over the years is that, in fact, in the last few years, is that they seem to give a particular provision, order, a perception of being ad hominem to facilitate the flavor of the day. But as these things go, when taste change or indigestion steps in, we may have to change our diet, even when the popular view is that it's the best thing since sliced bread, because we're looking for the best in the particular circumstances that we are. So in the High Court case that I referred to above, there was, what the court had to do is to interpret the Constitution of Trinidad and Tobago as it relates to this whole process. So we heard about the application of Ravi Balgovind Mirage, and we had interested parties like the Attorney General and the Commissioner of Police entering into the debate. At the end of the day, what did the judge rule? The judge ruled that it is declared that upon the true construction of Section 123 of the Constitution of the Republic of Trinidad and Tobago, the procedure for the appointment of a person to the office of the Commissioner of Police and Deputy Commissioner of the Police set out in Section 123, 2 to 5 applies to the appointment of persons not only to the substantive positions, but to act in the office of the Commissioner of Police or Deputy Commissioner of Police at any time when the office of the Commissioner of Police or Deputy Commissioner of Police is vacant, or the holder thereof is unable, whether by reason of absence or infirmity of mind or body or any other cause, to perform the functions of that office. It declared that the appointment of Mr. Gary Griffith to act as Commissioner of Police from the 18th of August 2021 was void and unconstitutional as being contrary to Section 123 of the Constitution. It declared that the Commissioner of Police and Deputy Commissioner of Police acting appointments, selection process number 2, Order 2009, was unconstitutional and void, being contrary to or ultra vires the provision of Section 123 of the Constitution. It also declared that paragraph 4 of the Commissioner of Police and Deputy Commissioner of Police Selection Process Order 2021 was superfluous and struck it out in light of the provisions of Section 123(2)(5) of the Constitution. Paragraph 4 of Legal Notice number 183 reads as follows. Where either the post of Commissioner of Police or Deputy Commissioner of Police is vacant or is about to become vacant, the Commission may submit to the President a list of suitably qualified persons from amongst the ranks of the police service, including those on contract or previously on contract, as nominees to act in the offices of Commissioner of Police or Deputy Commissioner of Police, pending the conclusion of the procedure prescribed in paragraph 3. The government's response to fill the void occasioned by the nullification of those orders was the enactment of Legal Notices 277 and 278. And these latter notices are what Senator Mark has brought this motion to have the Senate annul. I have looked at the whole situation very carefully. And at the end of the day, I asked myself, is there a need to annul these latest orders? In what way have they failed to comply with the constitutional remit? Have they significantly diminished the role of the Police Service Commission? I looked at 277, and I looked at the selection process, which really, I see, is a very important remit of the Police Service Commission. And I asked myself, are these things happening? When you look at 3.1 of 277, it says the Commission shall conduct a recruitment process, including inviting applications for the positions by advertising each vacancy in at least 2 daily newspapers circulating in Trinidad and Tobago on at least 3 days within a period of 7 days, that the Commission from the application received shall select the most suitable candidates for the assessment process, that the Commission shall ensure that the candidates referred to in paragraph B are subjected to security vetting and recent professional vetting, that the Commission shall conduct the assessment referred to in paragraph B and shall have regard to 1, the qualification and experience of the candidate, 2, a medical examination report, and 3, the security and professional vetting report. Now, at the end of the day, I have heard suggestions that it was wrong to remove the seniority. But anyone who has been, in fact, in management, anyone who has been in an employee, who has been in the working world for a long time, must realize that seniority and sticking to the principle of seniority is what has created a lot of problems over the years, both in the private sector and in government bodies. You have people who are there, they're given a position because they are the most senior, and the organization does not progress. It happens in the teaching service as well. You have somebody appointed, and nothing happens to move the school forward. But when you remove that person out, I spoke about it in a particular situation, another budget, immediately you see the changes that can happen. So the most senior person is not the best criterion for appointment. And really, to be hamstrung by saying we must have that person who is the most senior to act in a particular way, to occupy a position, Really, I do not accept that. I can give examples, but some of these are personal, and I would refrain from them on this occasion. But we have to be very careful. I heard it said today that this is a recipe for disaster. I've heard there's a recipe for chaos, and I don't see the disaster. I don't see the chaos, and I wondered where those recipes came from. Surely somebody is not as good a cook as I am and using the wrong recipes or not getting the correct mix to produce a delicious dish and something that could nourish and really send our society in the direction that it wants to go. I heard my loyalty is to the Constitution, and I go back to the Constitution, where the Constitution says, and the words 123.5, the Police Service Commission appoints the commissioner or deputy commissioner, but only after the House of Representatives approves the notification in respect of the relevant office. Does that provide the Police Service Commission with the last word? Can that be interpreted to mean that one must go with exactly the list, with exactly what the Police Service Commission has put before us? Or is it that these words mean something only after the House of Representatives approves the notification in respect of the relevant office? So, Madam President, try as I might, in all the circumstances, and I have tried, I find that I cannot, having read the law, having read the Constitution, and with my experience, I cannot support this motion to annul these orders. I thank you.
Senator Roberts. Senator Roberts.
Thank you, Madam President. Having spent my entire life in competitive sport, maybe I am naive, but I truly believe, respect, and honor the long-standing global tradition of fair competition. Let the best prevail. Work hard, be disciplined, strong-minded, push yourself to the max, respect the result of a fair, equitable, impartially judged competition. So observing, analyzing, researching, debating the various levels of executive overreach, intervention, interfering, interfacing, and influencing the process for the appointment of an independent commissioner of police by the Independent Police Service Commission has left me baffled, bemused, bewildered, and embarrassed for the members of the PNM government who've been involved in this process. Shame on them all. The PNM seeks to control. As I prepared for this debate, a statement made in this Senate by the Honorable Independent Senator Vieira, as we debated and discussed at committee stage a bill to create boards and a corporation for NAPA and SAPA, the independent senator noted Why so much ministerial control, too much control? Why you want to control? Let qualified people do their jobs. Select them and let them flourish. Those words just kept hitting me as I went through and analyzed this process. Control, control, control. I picked up my Constitution, 1976 edition, Republican Constitution, and I tried to see what was the spirit of the law. Because we talk about Section 123(2), and the government is trying to attempt to say that what they are doing is normal and fits in and it's not unconstitutional. But when I read my Constitution and try to think about the spirit of the law, the spirit of the Constitution, the spirit of democracy and the spirit of freedom, I see it being trampled upon on every avenue. I do not share the view of my former independent colleague because I can see it throughout, from the preamble of this Constitution to different sections, elements that have taken place to bring us here to discuss or debate Legal Notice 277, Legal Notice 278, and to void it and annul it. The mere fact that we are here shows that something is awry. It's a lot of effort, a lot of time, a lot of energy, a lot of intellectual capital being wasted as our people need us to focus on laws that will assist them, protect them, and keep them safe. A constitution created a democracy that we believe we have, and one of those tenets is the separation of powers. Separation of powers is critical for democracy, so that the executive branch can control certain aspects of life, make decisions that the government or cabinet may believe are in the best interest of the people, but that there are checks and balances, that an independent institution like the police is a critical element of a democracy and must not be tampered with in any form or fashion. And the mere fact that we are here today and we can go cumulatively to say that over 1 week of debate, discussion, parliamentary time has been spent on ins and out, changes, manifestations, drafts of orders, pulling back orders, amendments to orders, all to impact a process that should be independent. That alone should give us all time to pause. Democracy is on one end of the continuum of political systems. The other end is authoritarianism. And we in Trinidad and Tobago are in a dictatorship masquerading as a democracy. I read and I recall reading the Great Political Theories, edited by Michael Curtis, on page 222, where Burckhardt, the German political thinker, spoke about force and freedom. And when I read this, I was in shock. This was written analyzing political institutions and geopolitical positions and democracies and leaderships and government back in the 19th century. And he said, and I quote, the growth, Burckhardt, Force and Freedom, the growth of the power of the state. In the 19th century, it might have appeared as if the state were merely a police force protecting this multitudinous activity, i.e., industrialization in England, world trade, extension of colonialization, etc., which at one time looked at the state, to the state for cooperation in many directions, but ultimately only required of it the abolition of restrictions. And on the other hand, the state, as independently of all this development, as the temporary circumstances permitted, proclaimed its power as a heritage to be increased with might and main. Whatever possible, it reduced the rights of the ties. It reduced the rights of the lower orders to a mere fiction. There were and still are dynasties, bureaucracies, and militarisms which are firmly resolved to establish their own programs and not to submit to dictation. At the same time, political thought claims for the state an ever-increasing and more comprehensive power of coercion, so that it may be in the position to put into practice the completely theoretical political programs which political thinkers periodically draw up, the most turbulent individuals demanding the most extreme control of the individual and the community. And here we are today, seated here debating legal notice after legal notice, amended legal notice, meritless, collapse of a police service commission, appointment of a new police service commission, throwing out and discarding of a meritless to create a new one, all with the underlying thread of control. You know, I am a sports fan. So allow me to put this into sports terms for the people to understand what is taking place. Because sometimes when you talk about legalese and constitution, the people get lost. But when you break it down for them, they can understand it. It's as if we are all in a stadium. The whole population is watching with great anticipation a football match. It's the 85th minute of the championship match. And the VAR is checking the last play by the great striker Double G. Did he handle the ball deliberately, or did the ball play his hand? The VAR checks the result, and they said it was not deliberate, so they leave this big striker Double G in the game based on merit of the review. The crowd is excited, and play is about to resume. All of a sudden, the gaffer, the manager, raises his hand, signaling to the referee to stick a small pin in the game, to pause. He calls for a substitution. Starboy Johnny is to come off the field. And in comes the main man that the gaffer has faith in. He has been substituted to all positions over the season. He played from goalie to striker to defender to forward to water boy to physio. He dances his way onto the field, comes in this superstar that has the confidence of the gaffer. And in the most unorthodox manner, right footing, then left footing, straight up to the referee. He's talking to the referee, and the entire crowd is watching and wondering, what could this conversation be? All of a sudden, the referee decides he is going to review that last play. He makes the signal for his VAR review, and he himself runs across to look at the video as the game, and this results in the changing of the rules as the game is going on. After checking the VAR, the referee who had already ruled comes back and sends Double G off the field. He changes his decision based on a discussion with the substitute who came in. He takes the small pin out and resumes the game with 10 players on the field, leaving the whole crowd helplessly confused, literally at a loss. And this is what is taking place in Trinidad and Tobago. We have a system and a process, and the rules are being changed while the game is still going on. And yet it is not a game. It is very serious business that impacts the lives of our citizens that we are entrusted with keeping the care of, presenting them with a system that creates the opportunity for safety and security and upholding the Constitution throughout. But yet today, I come here and I could not believe, because we are seeing a situation where an acting Attorney General revokes the order drafted by the substantive Attorney General, and today the substantive Attorney General tries to defend the acting Attorney General's legal notice. Quite amazing. We are here now all of a sudden debating that seniority has no place. But what is seniority? The whole concept of seniority was based on merit, because it would assume, one would assume, that promotion through a police service or an army in forces that exist with ranks, that one would be promoted and become senior due to good performance based on merit, and they move up in the ranks. Now all of a sudden we are here debating that this government, this PNM government, believes that seniority is not a criteria. Therefore, the historical promotion process throughout the police service is negated and debunked. And therefore, one's track record for decades is ignored. And can we approve this? And why is this necessary? Why change the rules of the game while the game is still going on? The constitutional crisis which enveloped this country for weeks on end came about from a weak position that led to a weakening of the Constitution for weeks and weeks, making the police service weak in the face of a growing crime monster. This weak argument may appease
Senator Roberts, I just want to draw your attention that you are treating with the motion brought by Senator Mark to annul the 2 legal notices. But what you're now embarking on, you're straying from Senator Mark's motion. So I'll ask you to come back to it, please.
Thank you very much, Madam President. This weak argument may appease Senator Paula Gopi-Skoon, who is the Minister of Trade and Industry. It may be weeks before the President of the Police Welfare Society condemns this process. In May, weeks away. The preamble to the Constitution of Trinidad and Tobago used to oust an incumbent UNC government to install another PNM government by a president who was personally motivated so to do.
Senator Roberts, I ask you please to heed my advice and deal with the motion at hand, please.
Thank you, Madam. I'm dealing with the motion and the constitutionality as brought into the discussion about the orders, ma'am.
Senator Roberts, I have asked you to please try and be relevant to the motion. So clearly, I am not of the view that right now you're being relevant. I'd ask you please to confine yourself to the matter at hand.
Thank you, ma'am. The motion we are here to do today is to annul the order legal notice 277 and 278 amended to impact the independent process of the Police Service Commission. Senator Mark and the United National Congress believe that these legal notices and the quagmire and the imbroglio that brought us to this position are and go against the Constitution, which is the supreme law of the land. The preamble of the Constitution states at Section A, a society of free men and free institutions is what we want to create here in Trinidad and Tobago. But yet the PNM has started to change this, especially in this version of the PNM, to take control where the ministers control the TTRA, the Revenue Authority, appoint the board, appoint the Investigator General, appoint all the Directors General. They are putting doctors on boards and influencing independent institutions through promotion and profit based on appointments to executive positions. We saw in the economic zones that they were in interest of the power of the minister, whatever minister is in charge, to determine conditions for businesses. In the NAPA and SAPA corporate bodies, even Senator Vieira had to talk about the control.
Senator Roberts, please. You are embarking on debates that have been concluded, and you're also you're not linking anything that you're saying. You're speaking very generally, and you're not linking anything to the 2 notices that Senator Mark has sought to annul.
The 2 notices that Senator Mark wants annulled. It is the position of the United National Congress that these are ultra vires, that these go against the Constitution, that they should be annulled and rejected because they infringe upon the rights of the people of Trinidad and Tobago through their incongruous nature to the Constitution. I have just shown by Section A of the Constitution and now by Section B of the preamble, which states there should be opportunity for advancement on the basis of merit, ability, and integrity. Merit and ability. We are seeing that in these two legal notices, one, merit of all citizens who were not in the institution of the police have been negated and they will not be due for selection as contract workers. People on contract would not be considered for the substantive job nor to act. And that eliminates a lot of qualified citizens in the Republic of Trinidad and Tobago, which before these notices could have applied. Secondly, the amendment, legal notice 278, removes seniority. And seniority is in its essence a merit-based system, because coming through the ranks, one receives promotion because of performance, discipline, hard work, and ability. To remove seniority in legal notice 278 goes against Section B of the preamble of the Constitution. And this was used to thwart a merit list simply because the member or the leader of the executive arm of the government, where we operate in a democracy, where there is separation of powers, lost confidence in our human being. Ability matters not to the PNM. Simply look at the PNM cabinet. Scholarships have been made, turned and transformed into bursaries. Scholarships are based on merit. Bursaries are based on subjective processes and decisions. Financial institutions in Trinidad and Tobago with long-standing track records lose tender after tender under this PNM government.
Senator Roberts, you were on the right track and now you've gone off again. So I would ask you to get back on the track. Okay?
Thank you, Madam. I'm showing that merit is part and forms part of the Constitution of Trinidad and Tobago, as it's in the preamble and throughout. And that this government, in its decisions, not only in legal notice 277 and amended 278, but in other decisions has shown that their track record is to remove merit and create a different system of political control throughout, through their policies, through their practices, through contractors who are subcontracted to build central blocks at the hospital in Port of Spain, and the contract has collapsed because of that, and it goes on and on. Merit is a very important part of Trinidad and Tobago, and merit should form a part of all of us who are here. I could remember in 1988, for example, I was playing national under-19 football, training, and they were selecting the team and cutting it down to 18. Some members of that team were Dwight York, Colvin Hutchinson, Kona Hislop, coming down the line. I was unable to make the final 18, so I decided to go back into swimming. I got into the pool and I trained and I made the national team for the Carifta Championships in Jamaica. I had beaten, by the date of selection on merit, a young man named Lawrence Albada. And so I was selected for the national team. 10 days later, the National Short Course Championships, Lawrence Albada beat me to a pulp, coming and going in every race. But yet the national team, they said, had been selected. I went to the president of the association and I said, on merit, Lawrence Albada needs to wear the red, white, and black. I am taking myself off of the team to make a space available for him. That is how important merit is. So if we have a merit list that citizens have gone through a process and the merit list is duly authorized and approved by a majority of the Police Service Commission, and therefore alive, well, and legal, for an executive, for a government to intervene through a legal notice to impact the merit.
Senator Roberts, you are not dealing with the legal notices that are the subject of the motion. That you're not. And I will ask you, please, I don't know how many times I've asked you, but I will ask you, please, to be relevant to legal notice 277 and 278.
Legal notice 277 removes a section of the population from applying to and receiving a job of high merit, or a job that one has to work for their entire career. Legal notice 278 clearly removes the process and principle of seniority, which is merit, to ensure that people who may have earned an opportunity to perform a duty in this country are not allowed so to do. I am saying that legal notice 277 and 278 go against the Constitution of Trinidad and Tobago, as I just quoted from the section which stated, and I quote, "There should be opportunity for advancement on the basis of merit, ability, and integrity." I proffer that merit, ability, and integrity are espoused in the principle of seniority, and therefore legal notice 278 goes against the Constitution of the Republic of Trinidad and Tobago. We have seen it in this government. In our history, we have had attorneys general of great ilk, great silk, brilliance: Carl Hudson Phillips, Anthony Smart, Russell Martino, Keith Sobian, Ramesh Maraj, Sir Ellis Clark, Selwyn Richardson, Anthony Smart, Anand Ramlogan. And now we are forced here with an attorney general who cannot spell blanchishers and prints and drafts laws, brings them to the parliament, thwarts the Constitution.
Point of order, 46-4. Senator Roberts, I uphold the standing order. I uphold the objection. I will ask you, please, this matter that is before us is not about the Attorney General. So I will ask you, please, in your last few minutes, to come to the matter at hand, come back to it.
Thank you very much. This matter at hand is about merit, and the current Attorney General does not merit the position. What is wrong
Senator Roberts, I will ask you, please, to withdraw that statement.
I withdraw, Madam President. What is wrong with merit? Why so much energy and effort? Why so much thought and parliamentary gymnastics with regards to the appointment of a commissioner of police? Section C of the preamble continues, all persons may, to our Constitution, of which these two legal notices are starkly in opposition to the principles.
Senator Roberts, you have 5 more minutes.
Thank you. The spirit and the concept of our Republican Constitution. The preamble, section C, says all persons may, to the extent of their capacity, play some part in the institutions of the national life, and thus develop and maintain due respect for lawfully constituted authority. When one plays games and shenanigans in the process of selection and removes merit and removes seniority and creates a situation where political interference leads to the selection of the leadership of the police force, the police service, one would understand that the population will lose confidence in such a service. That is why this process was created, to be independent. The Independent Police Service Commission. And what has occurred over the last 3 months has left the population aghast and without trust in the leadership of the police service. A pristine process brings trust. A tainted process engenders disrespect. And it is our position that legal notice 277 and legal notice 278 taint the independent process of the selection of a commissioner of police. Policing requires community policing. It requires citizens to come forward with trust. But when people feel that there is political interference in the police service will suffer. Section 2 of this Constitution is the supreme law of the land, and any other law that is inconsistent with this Constitution is void. To the extent of the inconsistency, based on all antecedents bringing us to this stage today, I proffer that Legal Notice 277 is void. Amended Legal Notice 278 is void. The collapse and subsequent rapid replacement of the Police Service Commission is void. The rejection of a properly legally constituted and approved merit list is void. The current leadership, which owes its elevation to the compromise nutrition of the poison tree from the rancid root, manifested in the hardened heart of a lost, confused and dangerous dictator, is void. The PNM is void. The PNM must go, and that is mandatory. I leave you with this critical question. What would be so urgent, so important, or critical to make a prime minister, a cabinet, and or 2 attorneys general, substantive and acting, flout existing laws, the Constitution, the principle of separation of powers, the principles of fairness, merit, and propriety in this blatant, glaring manner, knowing full well that the population is watching, listening, discerning, and understanding exactly what is being perpetrated by this dictatorial, oppressive PNM government, and that they have responded politically in Tobago
Madam President,
already.
46.4 and 46.6, please, on a point of order.
Senator Roberts, once again, I uphold the objection. You have 2 more minutes.
Thank you, Madam President. The people of Tobago have already spoken, and the people shall similarly respond in Trinidad when given the opportunity so to do. Why would a government take such a risk to interfere in an independent process? Why does a government need to control the police? Why would a government require a legal notice 277 and 278 to prevent someone from attaining a job that they duly deserve so to be based on the merit list? Why? I ask why. And I leave it for the population to answer that question. Thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, I thank you for the opportunity to join in this debate on this motion. I thank Senator Roberts for his numerous sports references, and I will use one myself. I want to apologize to Senator Sobers, because clearly his captain today did not see that he should really be high up in the batting order to have made a contribution, because my friend Senator Roberts had nothing to say today. And I really feel that Senator Sobers may have done a better job. This motion raises one issue and one issue alone. And on that basis, it could be quickly dismissed. And that one issue is whether the orders before us, 277 and 278, actually diminishes the role of the Police Service Commission. The motion says significantly. And I'm just saying that the simple question is if it diminishes it at all. And I would argue to the contrary. Using the logic of Senator Mark himself, these orders improves the position of the Police Service Commission and improves it significantly. Senator Mark, in his attempt to build something more than those 5 important words in his motion, gave us the usual hodgepodge. saying that the criteria was not drawn up by the Police Service Commission but by the cabinet led by the Prime Minister, saying that as though it is something wrong. Well, that is exactly what the Constitution provides. Talking about seniority as though that is something so valued and honored in our environment today that it is wrong to interfere with it. Well, Senator Thompson-Ahye was right. This issue of acting only arises in one section of one notice. And it is not the first time. It is just another time in which the criteria for dealing with positions in the police service has been addressed, and I will deal with that. Senator Mark has talked about destroying the quasi-judicial police service commission, destroying the requirement of seniority, and the usual chaos and it being dangerous and so on. But there's nothing, and I'm about to say 8 things on that, on Senator Mark's presentation. The first is that I listened carefully. Senator Mark failed to demonstrate how legal notices 277 and 278 significantly diminishes the role of the Police Service Commission. He failed to do that. And on that basis alone, I should stop. But it would be dangerous if I didn't continue. I see Senator Sobers is back in the chamber. I'm so sorry, Senator Sobers, sorry. The second is, it fails to demonstrate a failure of the government to adhere to the Constitution. In fact, the government has fully complied with the Constitution. Senator Mark did not recognize that Section 123 of the Constitution is clear. And as Senator Thompson-Ahye properly pointed out, the responsibility and the responsibilities in respect of the police service, the police commissioner, the deputy police commissioner, the appointment process, the responsibilities shift through the Constitution. And Senator Thompson-Ahye correctly pointed out that there is that moment when the power of the Police Service Commission awaits the authority of the House of Representatives. And I say that to make the point that the authority of the Police Service Commission is not absolute in respect of the police service. It is not absolute. And it is through a process that the power of the Police Service Commission has been reduced over the years, and reduced with full support of my friends on the opposition side, including Senator Mark, as I will demonstrate. The fourth point I would make in relation to Senator Mark's contribution is this. Section 129 of the Constitution does not help Senator Mark's arguments. He knows that. Section 129 refers to the regulation-making power of the Police Service Commission. But Senator Mark didn't point out 2 things. The first is that regulation-making power in 129 is subject to the Prime Minister. It is stated there very clearly. Very clearly. But more importantly, that regulation-making power does not extend to the criteria for the selection of a commissioner or deputy commissioner of police. There's nothing there. In reading section 129, that does not descend into a selection criteria for a police commissioner or deputy police commissioner. The fifth thing I would say in relation to Senator Mark's contribution is this. Legal Notice 278, which he seeks to annul, deals only with clauses 4 and 5 of Legal Notice 277. You see, the main area in relation to the selection of the police commissioner is contained in clause 3 of Legal Notice 277. And 278 does not interfere with 277. And that is important because it is in clause 3 that we recognize it is the commission, the Police Service Commission, that plays the role in the selection of the Commissioner of Police. It is the Police Service Commission. And to tell me that 277 or 278 diminishes the role of the Police Service Commission, you have to show me that 278 interferes with clause 3 of 277. You have to show me that. And it is impossible for Senator Mark to show that. Because even with 278, the power of the Police Service Commission continues to exist. Ultimately, as Senator Thompson-Ahye correctly pointed out, ultimately, that power is subject to how the House of Representatives treats with a notification issued to it by Her Excellency the President. The sixth point in relation to Senator Mark's contribution is this. Talks about the removal of seniority. And I say that removal of seniority is only in relation to an acting appointment. As I said before, clause 3 of 277 is preserved. The issue of seniority, and both Senator Mark and Senator Roberts either missed that, misunderstood that, or deliberately miscommunicated that. The issue of seniority does not arise in the selection of a commissioner of police in this country. It does not arise. And that is clear in 277. The issue of seniority arose, as the AG pointed out, in 277. And 278 does nothing more than remove the references in 4 and 5 of 277 to this issue of seniority. And interfering with seniority has been a long process in this country. We recognize that. And not much of it was dealt with in the legislature. It was dealt with in the courthouse. And the legislature has had to comply. Because Trinidad, like many other colonial and Commonwealth countries, have treated seniority across its public sector as the criteria for promotion within the public service and within the public sector. And over a period of time, seniority as a criteria has been reduced. And it didn't start. It didn't start with 278. It didn't start there. It didn't start with 277. It didn't start with 278. In relation to the police service, we are in about the 20th year of significant dismantling of the old criteria and the promotion of a modern criteria for selection. And our friends in the opposition have been active participants in that process. The seventh thing I would say is that there is absolutely nothing in Senator Mark's contribution, as I have said, in 277, in 278, or in any constitutional amendment relating to the Police Service Commission, or in any piece of legislation since 2006 that diminishes the role of the Police Service Commission. We don't have it now under our government. We did not have it under the Patrick Manning government, and we did not have it under any government in between there. I could say that categorically. So Senator Mark's motion fails throughout. And there's no basis. There's no basis for us to deal with this motion in any other way but to dismiss it. You see, the evolution of this law relating to the police service, the significant evolution, and the removal of seniority is rooted in the Constitutional Amendment Bill of 2006. And I know the bill well, because under the Patrick Manning government, it was not easy. It was not easy to sell the change to even the members of the public. And it was not easy to sell the change within the police service. But I could tell you this, because by that time, 2006, I had been lecturing for more than a decade. And I had seen in my time at UE as a lecturer, I'd seen many police officers in my classrooms, many police officers. I had seen at my colleague Keith Beckles' school, many police officers. And I had taught, in many cases, taught free police officers A-level law, because I knew that the criteria had changed across the public service and including the police service, that it was no longer seniority, that in 2006, the amendment introduced on 20th April 2007, assented on 20th June 2007, changed the way in which police officers were promoted into the first division and removed seniority and used a simple expression, the result of the promotional assessment process. So we go back to 2006. It is not Minister Young. It is not the AG Al-Rawi. We go back to 2006 and before, and we see the dismantling of the long-existing seniority process and the replacement by a merit process. In the case of the 2006 bill, passed in 2007 and brought into law, it was on the basis of points. And one of the most important things in that was that a police officer who obtained a university degree put himself or herself in a very strong position for entry into the first division. It didn't start now. It started way back then. And my friends then in opposition supported that amendment. Around the same time, 16 May 2007, the House was considering, and eventually the Parliament approved, the police service regulations. A lot of things in the regulation were not new, but the police around that time were they were able to get comprehensive, written, Parliament-sanctioned regulation to regulate the way in which a lot of matters, including the promotion process, transfer process, was handled in the police service. And most importantly, Act number 6 of 2006. And that is a very important delegation to the Commissioner of Police. Because prior to Act number 6, 2006, it is the Police Service Commission that handled all matters of promotion, transfers, discipline in the police service. And you know something? When Dwayne Gibbs was appointed police commissioner in Trinidad and Tobago, and he was on the flight from Alberta to Trinidad and Tobago, I, writing in the Express, made this point, that Dwayne Gibbs was a third-level police officer in the city police force that he was leaving to come here. The force was about 20 to 25% of the size of our local police service. And I said that a police officer who had worked in human resources for so much of his life and who had never managed a force as big as the Trinidad and Tobago police force didn't have much chance of success. And it is on that basis and that thinking, the size of our police force. In fact, the police officers who were on vacation and study leave from our police force was more than the police force that Dwayne Gibbs worked in Alberta. And it is the basis of the size of our police force that in 2006, the move was made to give the Commissioner of Police complete authority over a huge section of the police service. And you know what? If that did not diminish the Police Service Commission, well, nothing will. If Senator Mark, who was in the Senate at the time and supported fully the delegation of the power to the Commissioner of Police, if he didn't see that at that time as diminishing the authority, the power of the Police Service Commission, then he cannot view 277 and 278 as diminishing the role of the Police Service Commission. He could not see that. Because that is the reality. From 2006, it became clear that if Trinidad and Tobago had any chance of dealing with crime and criminality and criminals, then the police service had to be modernized. And in modernizing the police service, we had to move away from the criteria for promotion. We had to give those university graduates in law, criminology, and other things relating to functioning in a police service the opportunity. We had to give the Police Service Commission a free hand in the selection of a commissioner. And we had to give a commissioner of police charged with delivering and being accountable to the Police Service Commission, having to submit periodic reports to the Police Service Commission. We had to give the commissioner the authority to manage the men and women under him or her. And as I say, if that was not diminishing the role then this cannot be diminishing the role now, 277 and 278. And in all the arguments, including Senator Roberts' attempt, I have heard no reference to what the Constitution really says in relation to the Police Service Commission. But I would say this, 123(1) is very clear, and Senator Mark cannot show me where 277, where 278, or where anything that exists from 2015 to now interferes with those powers under 123(1). And 123(1) is clear. The appointment of persons to hold or act in the office of the commissioner or deputy commissioner falls to the Police Service Commission. It is the Police Service Commission. But that is not even that. Even 123(1) is not absolute. Because as I've said, it is subject to the notification being submitted to the House and the House approving And as Senator Mark currently pointed out, and there are other officers who he could have referred to, a notification was made in respect of Devdat Dulalchan, and the notification was received, and it was debated, and it was not approved. And the Police Service Commission could do nothing, because it is the Constitution that provides for that power of the Commission, and it is the Constitution that makes it subject to that power of the House. And the process for the Commissioner of Police and Deputy Commissioner of Police, Senator Mark cannot show any interference with 123.2, because 123.2 sets out the process that has been followed. There is a nomination. It is in accordance with a criteria, procedure that is prescribed by order. And that is what 277 and 278 does. Because the criteria for selection is not set out in the Constitution. It is not there in 123. The criteria is prescribed by order under 123.2 of the Constitution. And that is what 277 and 278 properly does. It's not unconstitutional. Who else will set the criteria? And at no point, Senator Mark has been able to say that the Police Service Commission, however constituted, did not contribute to the creation of that criteria. At no point. But the creation of the criteria, the prescription by order, can only be performed by the executive. And if you have to change that, then you have to amend 123.2, because that is where the authority of the executive derives its power. And the other elements of the process of selecting a commissioner or deputy commissioner, at no point Senator Mark has shown us that 123, the submission of the list to the President by the Police Service Commission, and the issue of the notification by the President has been interfered with. At no point, nowhere in his motion, and nowhere in his submission, and I dare say nowhere in his winding up, would he be able to demonstrate that.
Minister, you have 5 more minutes.
So, Madam President, this motion gives us an opportunity to once again shine a light on the police service commission, the police commissioner, the deputy police commissioner, and the process. But looking at 277, no one can question that clause 3 of 277 at the time of its making, and to this day properly sets out the criteria and the role of the commission. The role is set out very clearly. 3.1a, the commission conducts the recruitment. 3.1b, when the applications are received, it is the commission that selects the most suitable candidates. And on the basis of that, it is in 3 that the order of merit list is created. And nowhere has Senator Mark been able to show that that has been interfered with. And that is the area that deals with the selection of a commissioner of police. And in 278, we see the changes. And those changes are in respect of one thing and one thing only. It is the acting appointment. And those changes in relation to the acting appointment does not diminish the role of the commission, because what was there before in 277 was a requirement that the commission deal with and order based on seniority. In other words, it was constraining the commission. It was doing what even Senator Roberts said should not be done. Because in 2006, my friends on the opposition was talking about meritocracy, was talking about giving everybody the opportunity. That is exactly what Senator Roberts said. Somebody was better than him and he stepped away and gave the person his position. And it does not, 278 does the opposite of diminishing. It gives, in relation to the acting appointment, the Police Service Commission, a completely free hand in order to determine which officer should act and the order of precedence and so on, without regard to seniority. And that does not, as I close, that does not diminish it, but it actually enhances the role of the Police Service Commission, and it continues along the way from the bill in 2006 right up to today on the work to modernize the police service, modernize the Police Service Commission, and modernize the way in which we allow the police service to be managed and to function in dealing with crime. Thank you very much, Madam President.
Senator Deyalsingh. Senator Deyalsingh.
Yeah. Thank you, Madam President, for allowing me to partake in this discussion today. And Madam President, first I might say this topic here today is very important to the ordinary citizens because you see, crime is a serious issue in our country. You know, the fear of crime is there. People, you know, we have a climate of fear in the country where people are fearing the COVID, they fear crime, and the failure to have a commissioner of police or a deputy commissioner of police appointed in a timely manner, the failure to have these important positions, lead to a lot of confusion, debate, things in the public domain we had before where persons were really worrying about, why all of this has to happen, and we had to deal with the pandemic and with crime, yet still in the public debate there were issues with the police service commissions, persons making certain allegations. So for the benefit of the country, we would need really to have the appointments of these important persons handled in a timely manner, handled in a manner that it would show the population at large that, we are actually on board with this fight against crime. So it's for the benefit of the citizens. And this section 277 and 278, persons may ask, will it really be diminishing the powers of the Police Service Commission? And I think this is the real the real problem that some persons may have. It was expressed that some persons may think it would, some persons will say it would not really diminish. And really speaking, when I looked at the legislation, ma'am, I realized that if you are expanding the age of the persons to be able to be chosen, this, in my opinion, may be a good thing. And why I think so is that if the Police Service Commission is restrained in having to pick the most senior members of the police service to be in a list, a merit list, we have to realize sometimes you may have difficulties if you have certain members chosen at the same time. then you have to make a decision who's more senior. Both of them join the service at the same time. You may have cases where persons may be a senior member but about to retire. So if he's about to retire, what would you do in a case like that? So those are decisions. Even if you have a senior member who you may have had allegations come into the private domain of the commission that this individual, there's some things, in his character, his dealing before that may be, sensitive. You don't want it to be publicly noted. If his name is left out in this senior list, that will lead to speculation, that will lead to embarrassment. So I'm saying it gives the commission actually a leeway to choose not just the most senior persons, but also persons from around the ranks who may not be at that senior level. So I think giving that leeway to them is an advantage. But madam, we have to realize the whole process of choosing a police commissioner, for years we had problems with this. We had instances where, as mentioned by Senator Rambharat, when the Canadians came in here, we had problems when they came in here. The leader of the opposition then, who is the present Prime Minister, he had some sort of objection stating, why do we have to go outside to choose outsiders to come in here? And the police representative, the union at the time, the police, they actually objected to that. However, the Police Service Commission at the time did have Canadians on the list. And you remember when they came with this and those individuals came here, some persons thought it was a breath of fresh air. Those persons brought in a first world mentality, how to have greater service to the people.
Senator Deyalsingh, if I may, we've had quite a number of speakers on the issue. And the issue as articulated by Senator Mark, it is his motion, is to annul these two legal notices. So I would ask you please to try and be a little more specific to the legal notices and to the motion filed by Senator Mark.
Yeah, thank you, madam. So, madam, what I was trying to get at is, even in that instance, I'm trying to say that changes that we have given to the Police Service Commission, how to deal with their procurement of how to deal with their choice of the commissioner, it happened before, because even after that, there was also another legal notice where it actually placed the burden on them now to choose just local persons. So definitely, you had instances where they actually got directives later on that it has to be a national. So even when that directive was given to them, it was not in any way meant to stymie their independence. It was to direct them on policy that we would have rather, have a local or a national of Trinidad and Tobago. So in the past, there were changes, there were directions given to them, and it was not really given to them in any sort of a way to, curb their independence, but to give them an idea how we should let things run in the country for our own nationals. So, madam, what I'm saying is that we have the legal notice 277 and 278 on the agenda today, and we have to realize that some of the concerns raised were the fact that if we are interfering with this, would we interfere with the run-ins of the Police Service Commissions? Will we somehow be able to being able to influence their decisions in terms of their ability to be controlled by the powers that be? Now, madam, I would like to just, if you allow me, to read in the Guardian newspaper. It was a Friday, November the 26th, 2021, where there's an article by Gail Alexander. She reported a new law made to select the new police commissioner. And in this article, it was made mention about some of the criticisms that came about of, when this legal notice 277 came about. And in the article, she said, the new legal notice 277 facilitates a fresh search for the COP and deputy COP. This means the merit list for the Commissioner of Police done by the previous PSC will no longer apply. The notice also changes the process to appoint an acting COP, limiting that to certain ranks of officers in the TNT police service and not contracted people. Now, Madam, some of the comments made against this was the former police commissioner, who slammed, as she wrote, slammed the changes, calling it a desperation by certain individuals in making changes to the criteria, including drafting a notice deliberately to ensure that Gary Griffith can't act as commissioner. So this was some of the criticisms came about by the former, that somehow we were trying now to get rid of him because he was a contracted person. So under the new notice, only officers holding or those acting in the office of Deputy COP or Assistant Commissioner of Police will now be considered. So therefore, also in the article, it said in an immediate reaction to the new legal notice 277, opposition Senator Wade-Mark said it was a move to debar former Commissioner Griffith from being a contender. Now, Madam, what we have here is that Senator Mark also said the pettiness was so blatant in this new notice, they made sure to remove the aspect for contracted people to act as COP, limiting it.
Senator Deyalsingh, yes, I know that you're making reference to a newspaper report that made reference to the legal notice, but you're spending a little too much time on who said what, as opposed to dealing with what is before us. So Senator Mark, quoting what he said as referenced in that, it's not relevant because he has already moved the motion here. So I'll ask you to tie in.
Sure, thank you.
Okay, please.
So, Madam, what I'm looking at is that since, well, this article suggested that the opposition then, or Senator Wade-Mark's position was that they were seemingly backing the appointment of Mr. Griffith. And, I find it strange, Madam, that even notices that come before, when in 2018 his appointment was actually tabled, the opposition then resisted it. They actually didn't vote. So you had instances where sometimes when the government is in power, there's one thing. When the opposition in power, there's another thing happening. And in all of this, it is really the population who sometimes want to know what's happening. I mean, it's a state of confusion where you are backing a candidate at one stage, and another stage you're not backing them. And it goes on both sides. It goes on both sides because even persons had accused the government when they were in opposition for, when Mr. James Philbert was going to be appointed. Again, he was left dangling. So the whole idea of having the 277 and 278 come about, it was actually due to the brilliant judgment of Justice Kangaloo, who actually tried to clear up the state of confusion that the country found themselves in. So we have to be thankful that the Ravi Balgobin Maharaj and his attorney actually sought to clarify some of the issues that were plaguing the nation there, where you had a state of confusion, you had, as people may say, couture happening, problems happening, and that judgment actually listed certain aspects that, certain aspects, certain legal orders before as being unconstitutional, illegal. So therefore, I think government's attempt today in bringing this is to somehow serve to look at what the judiciary had said, look at what the judge had said, look at what the fact that the state of confusion was eventually being tackled in the judicial arena, and having regard to that, the government, I think, has the added responsibility now to make the process as clear, as easy as possible, because in the past, what actually transpired, Madam President, was a disservice from both government and opposition, disservice to the persons, to the population who, for years looking for some quick remedy to this appointments of the commissioner and the deputy commissioner of police. So this here today we are looking at this, and I'm thinking that any piece of legislation which can clear up the state of confusion, any piece of legislation which can actually get the Public Service Commission to do its function better, to perform its function better, it's a plus. The allegations that some may think that the Police Service Commission may be somehow being tampered with, I think it's an injustice to say that, because the members there, headed by retired Justice Jones and her committee, I mean, if we think that they could be somehow influenced, I think we are making a mistake, because we are giving them guidelines. Those persons could look at the age of the seniority. They could decide on their own now. They can pick somebody young. And those persons, I think, we are actually widening their ability to choose individuals. We are actually giving them that power. And in a sense, I'm thinking we are going to give them the power to choose the best candidate that they can put forward. The problem we will still have is if you're looking at control, if this, the part of the argument is control, when those names come to Parliament, we will still have the fact that you could be somehow with the parliamentary majority, the government in power could have its day. So it don't matter what, because we have seen before with Stephen Williams, his name was there, and a previous member, I think it was Pastor Dottin, who was at the Police Service Commission at the time, threatened to resign. He said, look, after all our hard work, we put our names forward, people on, you politicians are not accepting these names. So the fact of governmental control, it will still be here for the majority, the government in power. But the idea is the candidates coming forward, the list coming forward, the merit list coming forward. We should have confidence in the new Police Service Commission for bringing this list forward. That is not to say we shouldn't have, we should have lost faith in the old Police Commission for all the activities, madam, because remember, I think it was today's newspaper, there was an article stating they acted as, as a matter of necessity when they were chosen. So,
yes, Senator Deyalsingh, I just want to draw you back to what we are dealing with and to ask you to not deviate from the matter at hand.
Sure. Yeah. So madam, I also would like to bring to the point, I think someone had mentioned, since the judgment transpired, what would have happened to all the matters with the police commissioner, the deputy police commissioner, and I think a speaker mentioned that, but I think Justice Nadia Kanglu in her judgment, said that, even though she also quoted the doctrine of necessity, where those persons would also, their decisions that they made when they were in office, would also be kept, because she pointed to two legal principles, the de facto officer principle and doctrine of necessity, to preserve their actions and decisions. So I see, Madam President, a move here in the right direction. I see a move here to make the process easier. I think the process, I don't see anything sinister in it. And I think if we go to question, question the fact that the Police Service Commission may now be somehow be tainted or somehow be controlled, I think we would be doing injustice to those officers there. So in all, madam, I would say I would like to give my support to this, and I have seen nothing in this to have me having any major concern. And one thing, madam, I must say is when I looked at the new legal notices, I still think it might be a mistake sometimes not to be able to look elsewhere. That, because sometimes you may need persons coming in with a mindset that, could help our situation down here with, and I think probably the AG may have to consider that, that every so often, yes, we need locals, but we also need the persons with a first world mentality to come down here, give us some sort of guidance, and also have us in a global way where we can get those persons who probably may be more independent because they would have not been within the system under any sort of guides of any sort of of politicians before people could say they know these politicians. So in conclusion, I have to say this brings clarity, it brings a little more certainty in these important processes. I pray that the persons now occupying the Police Service Commission now police know that the important role they have to play for the country, and those persons who are so chosen as the Deputy Commissioner of Police and Commissioner of Police will eventually realize that they owe it to each citizen to be fair and independent and to fight in our battle, against these criminals. Thank you, Madam.
Senator Lutchmedial.
Thank you, Madam President, for the opportunity to contribute on this motion today. Before I begin, Madam President, and you will notice that I'm sniffling. I can assure you that it only happens when I'm in the coolness of the chamber, but out of an abundance of caution, I will keep my mask on. Thank you. Madam President, where do I begin? My perspective on this issue is, of course, a little different from everyone else's, having been intimately involved in the two cases that have been cited here, or I should say misquoted here sometimes, and that is Harriet Maraj versus the Attorney General, and the recent case of Ravi Balgobin Maraj versus the Attorney General. Before I start to correct all that has been said about those two matters most erroneously, and I have to say it is really disappointing to hear the law as set out in judgments from distinguished judges, and as someone said, judgments which have brought so much clarity, both of them statutory interpretation claims brought by litigants, public interest litigants, to correct missteps made in the appointments processes. But before I get to those things, I just want to raise some issues with respect to the present order that is here before us for debate, and this issue of seniority. I have to congratulate Senator Mark for giving a very thorough and comprehensive overview of the issues that relate to this matter. And I think that it is only redounds to the benefit of this country and the public at large to have these matters ventilated, because they must understand. And somebody, I think it was just the previous speaker, said that when we had all this couture taking place last year, right, the public was left in a state of utter confusion as to what exactly was happening with the appointment of a commissioner of police. Now, many appointments are made in the public service, but none of them attract as much attention as the appointment of a commissioner of police. And there's a reason for that. And it has to do with the amount of power that this person has and the amount of the impact that they can have on the lives of ordinary citizens. So the independence, the neutrality, the transparency of that appointment process is of fundamental importance to the average man and woman in this country. And that is why these orders that set out those processes are so important, and it is why we have to examine them very carefully. And we do not want even more missteps being made, because I don't think I need to remind anybody of the disaster that we had on our hands last year based on bad legal advice, bad drafting, a misunderstanding of the Constitution and how subsidiary legislation works by many persons in government and those appointed by the government in the Service Commission, where we had for the first time in our history no Commissioner of Police. Do we want to send this country back down that road? I do not think so. Nobody wants that. Not government, opposition, nobody. That was a disaster. And so if we want to avoid these disasters, we have to very critically examine these orders that are here before us. Minister Rambharat made reference to the fact that seniority has been removed over time and whittled away. And that is true to some extent. But even after the 2006 amendments, these very significant amendments that really changed the whole role and function of the Police Service Commission and remove the power of veto, although some people, through their actions have basically given themselves back the power of veto. Essentially, that's what happened when a merit list goes missing. You give yourself back the power of veto. But nevertheless, even after the 2006 amendments, in 2007, the qualification and selection criteria orders that were made still made an allowance for the Service Commission to consider seniority and experience. So, for example, in legal notice, let me give you the number. It is 165 of 2007. And again, I think this exact clause was replicated in 2009, where they set out the selection process criteria and so on. There was an allowance made for people who did not have the criteria, and it capped the marginal note to this order. It talks about serving officers. And it said where an officer does not hold the qualifications stipulated under paragraph 2A, but meets the core criteria listed in paragraph 3 and has 20 years experience or more in the police service, he shall nonetheless be considered as a candidate for appointment. Now, this deals with, of course, the appointment of a permanent commissioner of police. But you see, even back then, it was recognized that experience goes a long way in the police service. And as someone who has worked very closely with the police in my previous incarnations and still interacting with officers in court every day and so on, I could tell you there's a lot of value to be placed on experience and seniority in the police service. And the removal or the less weighting that is given to seniority, to me, really doesn't always produce the best candidate. I agree that sometimes the reliance solely on seniority may mean that the person who has just been sitting in the chair for the longest period of time eventually gets elevated. But you have to have a balance. Because in something like policing, there's nothing teaches you policing, There's nothing that teaches you how to be a police officer other than field work, investigative work. You see that man who sit down there writing in station diary, like Sergeant Adams and them? That, you have to be able to do that to be able to learn how to do police work and how to do investigative work. So there's a lot to be said for seniority, and I think that it was recognized even after 2006 that you must give some allowance for seniority. Because what you have happening, and I say this without fear of contradiction, is that there are officers, young officers, who might have about 10 years experience or something like that, but they have more degrees than all of us in here put together because they've spent 10 years on study leave. They move from one study leave to the next study leave. They work in administrative office positions within the TTPS, the chief clerk's office or one of those offices where it's basically paper pushing. They never have field experience, but they're studying. They are studying. They take, there's a program at Cipriani College, and I have nothing against people studying, do not get me wrong. But that emphasis solely on qualifications now, and that greater emphasis being placed on qualifications really sometimes does a disservice in terms of selecting the best person for the role of for promotion, and it will ultimately filter into the roles of Commissioner and Deputy Commissioner of Police. I want to point out one very important thing when it comes to this particular order of 277. Clause 3 deals with the process of the appointment of Commissioner and Deputy Commissioner. And there's no reference there to seniority and so on, because there is a process. There's a process that they have to go through for grading and so on. They get the applications, they do the assessment, they do the vetting, medical, security vetting reports, all of this, and then the commission does its merit list. What is a merit list? After you go through the entire process, you rank your candidates. 1, 2, 3, 4, 5, 6, 7, 8, 9. When you come to acting appointments, what Clause 4 really says is that when you're dealing with acting, they establish and maintain an order of merit list, which shall list, and now in the amended version, officers who hold these particular offices. So I believe there are 3 deputy commissioners of police, and I think in terms of ACPs, there are about 8 or so. So you have essentially 8, 9, 10, 11 people who will be on this list, and they have to possess the qualifications and experience required for the appointment of Commissioner of Police. So if they all possess these criteria listed in Clause 3, they make the list. So out of the 11, let's say you have 7 of them that have this, and they are currently holding the office of DCP or ACP. Well, how do you rank those 7 people? There's no interview process. There's no process for medical. There's nothing in Clause 4 that says they have to go through security vetting. There's nothing in Clause 4 that says they have to do an interview. There's nothing in Clause 4 that says these people who will be eligible to act, whether as a DCP acting as commissioner or an ACP to act as DCP, that they have to go through that promotional assessment process. So how do you rank them, if not by reference to seniority? It is as simple as that, you know. And yes, we're talking about other things and about the motives and how it was changed in the middle of the night and the dead of night and all of that happens, but on a common sense level, on a practical level, do you know what you're going to have? You are going to have anywhere between 1 and 11 names who meet the criteria set out in Clause 4.2, yes, Clause 4.2, holding an office, possessing the qualifications and experience, and the commission will then just randomly choose a name. And what you will have is out of them, those 11 people, when one is chosen to act, the other 10 could challenge it. Because on what basis? What is the basis upon which they will make that decision, if not seniority? So the day that the Police Service Commission have the names of all the people who meet the criteria in 4.2, A and B in front of them, I mean, what's it going to be? A pick-a-pan? You'll pick one out of the hat? They will just have to choose one of the 11. And the other 10 can go and file judicial review. They will challenge it. They will want to know on what basis, because how else do you rank these people? So from removing seniority, I perhaps I will give the benefit of the doubt that perhaps it was not thought out properly. We've seen many pieces of legislation, particularly when it comes to the selection process for a Commissioner of Police, not well thought out when they are made. They need to stop drafting in the middle of the night and fixing things in the middle of the night. But clearly, nobody thought about how the Police Service Commission is to differentiate between one and the other. The answer is found, and as Senator Mark rightly said, in other regulations that deal with the appointment of public officers. You look at seniority. That is like the tiebreaker that exists in the public service regulations, and he quoted it. I'm not going to waste time going back and say it. He quoted it for you here today. So I'm asking members of this House from a common sense perspective, Forget the bacchanal, the politics, the lacqueray, all of those things. From a common sense perspective, do you think this thing can work? Or will it create a situation where you could have more litigation coming forward, where you could have a service commission having to tell itself, well, out of necessity, I might choose this one or that one, where you could have members of the Police Service Commission actually, being challenged on their discretion and how they exercise that discretion and so on, being forced to account before the court. I cannot tell, if you do a search, a simple search on the Judiciary, the Law Library website or anywhere about the amount of times police officers have challenged merit lists and appointments and promotion lists and so on. I mean, it is never ending. I remember a time I was involved in a matter where there was an injunction blocking an injunction, or there were two sets of injunctions blocking different groups of people who wanted to be promoted in the police service. It was a total and complete mess. And the last thing you want to do, and I say this over and over and over, the last thing we want to do as a parliament is to allow a piece of law, be it primary or subsidiary legislation, to go out there into existence and create havoc, create circumstances ripe for litigation, and, when it comes to something as important as our police service, to create uncertainty in the minds of the public as to whether or not there is some sort of ulterior motive involved here. Because you see, and I know that the government and the government bench and speakers and so on, ministers and the Attorney General will say that, we are like conspiracy theorists. We always think that there's something, some bad intention, and this is just, we're trying to simplify, and this is for the good of the country and all of that. But take this debate in its context of what has transpired. This is the third time this government is trying to tinker with the process. The last two times, they had to go before the court, and I don't know how the state taking a position, having litigation brought against it, having a judgment striking out portions of the legislative instrument that the state produced, being ordered to pay the litigants' cost, could still stand here today and heap praise upon themselves for the order was deemed constitutional. I don't know that members opposite understand the meaning of the word ultra-virus. If something is held to be ultra-virus, it means that it is beyond the scope of the power of the maker of the decision. It is out with the parameters of the Constitution. It is unconstitutional. To say that the court upheld the constitutionality of the order because certain aspects of the orders remain, that is misleading. It is misleading the public, the parliament, and anybody else who does not know. But I drafted that Harriet Maraj claim, and every single point that we raised about aspects of that 2015 order that we said violated the Constitution, violated the Central Tenders Board Act. Every single aspect of it was upheld by the court. And so they amended the order. They literally, if you look at the judgment, draw lines through all the offending parts of it. So I don't know where the Attorney General, I think the fireworks is affecting him. I don't know how he comes to this parliament and tries to avoid the reality. The reality of the situation is that on 2 occasions, these orders were found to be offensive. Whether you use the word superfluous or not, the point is, based on the advice of the Attorney General and his considered legal opinion, given through the media, we had the acting appointment of Mr. Griffith revoked. So the importance of this, and whether or not the government is doing this thing properly, and whether or not this order will stand up to scrutiny, it must be at the forefront of everyone's mind. It must be at the forefront of our mind and any right-thinking citizen of this country, because we've gone through the experience twice, and we do not want to go through it a third time. So again, anybody to tell me, how do you differentiate those candidates when you remove seniority from the requirement contained in Clause 4 of Order Number 277 of 2011? I don't intend to use all of my time, but I just want to wind up saying one thing. It is recognized in the police service regulations, which, unlike these orders that are made in the middle of the night and amended in the middle of the night by the government and take effect right away, and would be the law in effect unless the opposition brings a motion to negative. The regulations, the police service regulations, are subject to affirmative resolution. They have to be approved by the Parliament. And that, in my respectful view, gives it a lot more validity and force. It went through that process in 2007, when they were passed. And one particular provision, very important provision in those regulations, that deals with conduct of officers. It talks about the officer in his second division who is in charge of the station and his responsibilities and so on for a station and the district, and the conduct and efficiency of all the officers under his charge. A very serious duty. I don't know if anybody ever observed when you walk into a police station and you see the notices on the wall and things, and it says SDOIC, Second Division Officer in Charge. That is a very important position that you hold in any particular police station. Whoever is that SDOIC, he's the man on the ground. He is the man or woman to make daily operational decisions in a particular police station. And let me quote from Regulation 133.4 that says, in the absence of an officer referred to in Subregulation 2, Subregulation 2 speaks about the first division officer who will be responsible for the state of his command and so on, right? And it said, in the absence of the officer referred to in Subregulation 2 or 3, the authority and responsibility of that officer shall devolve upon the next in seniority unless the commissioner otherwise specifically directs. So our police service regulations, drafted, brought to the House, debated, passed, subject to affirmative resolution, recognizes the role of seniority in the TTPS. So I've said a lot about why I think it's important, but here it is. Here it is, right here, written into the police service regulations, of the importance of seniority. The police service is an institution that operates on instructions from seniors. And that senior, when they talk about my seniors, anybody who knows a police officer, I think that one of my colleagues mentioned before on the other side that her father is a police officer. So she would know, you grow up here, my seniors say this, my seniors say that. That is how the police service operates. And seniority is rank, but also, you see that thing they call regimental number? They respect that in the police service. It is the culture of the police service. So it is not just part of it is not just a logistical problem for the Service Commission to be able to grade and rank these persons who qualify to act under Clause 4, but it's also, it goes against the grain of what is really the culture of the police service, that seniority matters. So if the government is serious about having a process that can work, having a process that would not be subject to challenge, having a process that will not result in more, and I have to keep using the word because I haven't heard it for such a long time, that Senator Deyalsingh used, more couture and bacchanal and just, complete upheaval in our police service. I think they need to give some serious consideration to whether or not it is right to remove seniority as a requirement from this process. I do not at all agree that including seniority is a factor on the discretion of the commission. Because you see, right here in this section, you are limiting the persons who the commission can place on that merit list. They must have that particular rank. They must have been promoted to the rank of DCP or ACP to even get onto that list. But the commission must have a way to assess them. It's not whether, who comes number one? When out of the 11 of them that qualifies, you have 7 who qualify to be on this list. How you pick number one? Because you like how he's look? Or because we will have another situation where you will have allegations of political interference and instructions being given, because that is what the country is afraid of. That is what the opposition is afraid of. That is why when a government minister signs an order today and within 24 hours he changes it, the opposition is alerted. We literally, and I think many people in this country literally stopped and said, but is it that whoever was number 1, 2, and 3 on the list didn't meet with the approval of somebody, so they decided to change the order because they really want 5 and 6 to be appointed? These are the types of speculation.
Senator, as much as you're making your statements, and you should have just about 5 more minutes in your contribution, be careful about imputing improper motives in relation to the list and any attempts to do anything to the list.
I'm guided.
Okay, continue.
I'm guided. And my point is that you want to avoid that type of speculation. You want to avoid the feeling amongst the population that there is some nefarious intent. You do not want persons living through the experience that we lived through last year of a clause that was basically what we call in law ad hominem and created an opportunity for an acting appointment for someone being then ruled out of order and superfluous and really unconstitutional, or the actions of the commission pursuant to that order unconstitutional. The same population, the same people following that matter, living through it, you do not want a situation where they have to now question what are the intentions of the government. Is it that there is some intention, and I'm not casting aspersions and I'm not saying it. I like to wait until evidence presents itself, which it has done quite adequately in the past. But in the interim, I have to say that the manner in which this amendment came, the fact that it makes absolutely no sense, and the fact that it is impractical for the purposes for which it is intended, it leans in the direction of making someone believe that there's something amiss and there's some other intention here. So, again, with the greatest of respect to the drafters and those who may have given their advice and opinions on this matter, I say it is unworkable and it ought to be reconsidered. And this legal order ought to be revoked, withdrawn, and some serious consideration given as to how that acting process ought to really take place. Thank you very much.
Senator Dillon-Remy.
Thank you, Mr. Vice President, for allowing me to join in this debate where the Honorable Senator Mark has asked the Senate to consider the motion to be it resolved that the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2 Order 2021 and the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2 Amendment Order 2021 be annulled. Mr. Vice President, we are here again debating an issue that we debated in this House on July 5th, 2021. And when I reviewed that motion, It is similar to what we debated in July 5th, 2021. The only things that are different, the only words that are different are the numbers of the legal notices. Legal notices 277 and 278 have replaced legal notice, I think it was 183 at that time. Sorry. I don't remember the legal notice number then, but the only difference is the legal notice number. Mr. Vice President, my concern today is when we debated that motion by Senator Mark, which was he wanted to annul the then legal notice of 2021 then, all the things that we debated at that time were of no relevance when it came to be challenged in the court. Because, I'm saying that because when I heard that in August of that year, last year, that Justice Kangaloo had annulled the notice of, it was legal notice 103 of 2009 and legal notice 183 of 2021, which is one we debated in July. I said, I wonder where we went wrong. And I looked back, and what was brought to the Parliament, the Senate at that time, was the same thing, that we were the legal notice overstepped the powers of the Police Service Commission. And I remembered going through the motion, and I did not think that there was any overstepping of the Police Service Commission's power. And that's the same thing we are debating again today. When I look back at the judgment from Justice Kangaloo, and in part it said, it is declared that the Commissioner of Police and Commissioner and Deputy Commissioner of Police Acting Appointment Selection Process Number 2 Order of 2009 is unconstitutional and void, being contrary to or ultra-vires the provisions of Section 123 of the Constitution. And it is declared that paragraph 4 of the Commissioner of Police and Deputy Commissioner of Police Selection Process Order 2021 is superfluous and hereby struck out in light of the provisions of Section 123(2) to 5 of the Constitution. The point here is that last paragraph which says that the order we debated, all she said about that order was that paragraph 4 was superfluous. In other words, there was no evidence in my mind that what was said in that order diminished or interfered with the power of the Service Commission. We are here again to do the same thing. And Mr. Vice President, I agree with Senator Hazel Thompson-Ahye, who talked about our processes being mired in confusion. Why, as a small nation, we can't get it right? And as Senator Lutchmedial just said, in other words, we seem to be going around in circles, giving opportunities for things to be taken to court. And at the end of the day, all the confusion about whether we have a Commissioner of Police, Deputy Commissioner of Police or not, it is just not acceptable. And I would hope that what we are doing today does not result in something like what happened last August. Mr. Vice President, I have to ask this question. I heard Senator Rambharat talk about the fact that seniority, he said in the Act 6 of 2006 about the delegation of the powers of managing the police service to the Commissioner of Police was something that was done to modernize the police service. And we are here in 2021, with an Order 277 that talks about seniority, which has to be removed by another Order 278 the next day. Mr. Vice President, I'm just concerned about something like that. In other words, if there's history about seniority not being an issue or not being so important now, why is an order being made in November of 2021 where seniority is put as it was put here in clause. It was put in the clause as it referred to the selection of the Deputy Commissioner, acting Deputy Commissioner of Police. Why is it so? It is clause. So in legal notice number 277, clause number 4, that deals with the selection of an acting appointment to the Office of Commissioner of Police. And it says subclause 2 talks about listing in descending order of seniority. And as I was said already, all the issues about descending order of seniority, they have been removed in the clause, in the amendment Order 278. Why did it reach there after so many years of modernizing of the police service? I just have that question to ask. And the reason I'm asking that is, as Senator Lutchmedial just said, we do not want any more, at least we prefer not to have, knowing that the responsibility of the Commissioner of Police is so important. And it does not look good. And it just does not look good for the government, but it does not look good for the Parliament. And I'm asking why something like that would have got into the order that had to be rescinded the next day. Mr. Vice President, I would cut my presentation short. I noted all the aspects of all the clauses of this Order 277, and as the Attorney General said, was similar to orders that were done before. For instance, when we came in 2021 July, it was to make right the wrongs of the order of 2015. And these things that are here in this order, in Order 277, are in keeping with the judgment that was given at that point in time by Justice Rajkumar. And these things are here in this order, and again, I don't see that there's any evidence there that they're removing the powers of the Police Service Commission. Mr. Vice President, the other area that I would mention is that in consultation with a senior police officer in Tobago about the thoughts about these legal notices, because I thought it was important that we have removed the issue of removed here seniority, and as Senator Lutchmedial said, this is something that is important in the police service. I asked for the opinion, and the senator and the senior officer said that Section 277 sets out the procedures to be followed by the Police Service Commission in selecting persons to fill the post of COP and Deputy Commissioner of Police, both substantively and for the purpose of acting. And that Clause 4 of the notice deals specifically with the acting appointments in both offices. And that legal notice 278 sought to amend Clause 4 of Notice 277. And he said, the amendment sought to give the police service the level of discretionary powers which either did not exist sufficiently or at all. And as the Attorney General has said before, many of the previous judgments against the government were precisely to give the Police Service Commission the autonomy that it needed. So in this particular order, the officer is saying it does give the Police Service Commission the laterality that it needed in carrying out their functions. In other words, they can select a person whom they think fit and qualified to act. They do not have to go with seniority, and he thought that that was a good thing, because the Police Service Commission is a creature of statute and must follow the law, and is not empowered to exercise wide discretionary powers. In other words, they have to do as they have been given by the Constitution. And therefore, 278 sought, this is the opinion, 278 sought to remove the yoke from around the neck of the Service Commission and sought to allow it to exercise the level of discretion. And he thought that this was no doubt a crucial thing for the Police Service Commission, and that the amendments were a good thing. I wanted to say in the clause 4 of the order number 277 that talks about acting appointments, what I understood the removal of the issue of seniority from that clause, or from everywhere that is mentioned from those clauses, to me it never said that the commission cannot select somebody who is senior. It is giving them the powers that they can, if they want to, based on the criteria that they have in front of them for selection, the powers that they have given to them. I do not understand how we can say on one hand you want to stifle the commission by telling them what to do on one hand, and then when you give them freedom to do something, you are saying that is you're not allowing them to be guided by the law. In other words, you want to put the seniority in to guide them. On another note, you're saying give them the laterality. It does not make sense to me, Mr. Vice President. And I am just asking that from my observation of the law, and I'm not a lawyer, I know there are many more experienced people here, this Order 277 does not diminish the power of the Police Service Commission, which is what the motion says, and therefore I cannot support the motion. Mr. Vice President, I thank you.
Senator Sobers.
Good day, and thank you very much, Mr. Vice President, for acknowledging me and giving me an opportunity to make a minor intervention here this afternoon on this particular motion that is currently engaging the attention of the Senate. Now, this is an important motion that has in fact been brought by the opposition for many reasons which have been traversed by many speakers throughout today's proceedings. It is squarely tethered and linked to certain scenarios that have well traversed the media during the period of June to maybe November of last year, all of which I think everyone within this chamber and persons listening and viewing at home are quite okura with. And that particular situation, those events that transpired last year, are extremely important. And so the forces coming out of such an event, I think, are in fact worth some type of debate. I was commenting to some persons recently that whilst that situation was ongoing, I don't think many persons within the public truly understood exactly what was taking place. You see, you have a situation where there's the Constitution that indicates how a particular individual, an individual of extreme import, an individual with an essential role and responsibility to captain, to pilot, to manage another very important structure and organization within our country, one that has a responsibility to ensure that law and order enforced within our country, that there's peace within our borders, an institution that must be seen as fair and independent and free from political interference. And what transpired during that particular period, I think, trusts a lot of persons and forced a lot of persons to think about this in a very negative way. That those very same tenets that I spoke about, that this institution is supposed to be constructed upon, kept together upon, were affected in a very real way. That I think for most of us, we may not have seen within our lifetime. And it is connected, rather, to trying to understand how such a situation or the genesis of such a situation was enacted. So Senator Mark and others would have spoken about the Constitution and what the Constitution says and whatnot and whatnot and whatnot. And the Police Service Commission has an extremely important role. We all know this. It has been said several times during the course of debate today. And what the Constitution indicates in short order with respect to the appointment of this individual, this Commissioner of Police, acting or permanent as the case may be, is simply that this service commission, just like other service commissions, would have this rule. They would create a list, and the person who tops that list, they will forward that list rather to the Parliament for debate, and the person who tops that list would be sent to the President, and you would eventually have a Commissioner of Police. And that is in its simplest fashion. And the procedure by which such an appointment or recruitment exercise is governed is through these legal notices, which is referred to in the Constitution as the order. And I think what a lot of persons failed to realize back then and what they understand or appreciate now is that these legal orders are in fact created by the government or the administration of the day. And prior to the events of June, thereabouts, in 2021, you would have had two orders generally that would have governed how a police commissioner or acting or permanent would have been appointed. And that would have been an order in 2009 and one in 2015. And they were orders that were tried, tested. The courts had difficulties with the 2015 order, which would have been illuminated in a particular case that was already properly spoken about within this debate. But before that, that was the system that was being utilized. And we would have had many commissioners of police and deputies of commissioners of police being appointed accordingly. And then you had a situation where in 2021, with that order of 183 that was birthed, caused significant issues. And in our opinion, as a responsible opposition, those issues, with the greatest of respect, were carried over into the 277 and 278 orders, which we are discussing here today. In terms of my submissions, my issue really and truly is this. There is a significant segment of the population, Mr. Vice President, that believes that what has transpired over time may not have been what the framers of our Constitution envisioned when they dealt with that Section 123 as it pertains to the Police Service Commission. There's a significant segment of the population that believe that there is or there should be a significant degree of independence in terms of appointing someone as important as a police commissioner. And with the fluctuation of time and the growth of society, understanding then that role and function is really dictated by the administration, I think for a lot of persons within our country is very new. It is something that has been on the books for quite some time, but it is still quite a new concept for many persons within society. And in my opinion, when I looked at the 2015 order, and I juxtaposed that with what obtains now what obtained in the 183 order of 2021 and the 277 and 278 orders, that if there was any belief that the system in and of itself, the recruitment process in and of itself, was totally independent, in my opinion, it has been felled or even eroded totally. When I looked at what transpired in 2015 compared to the 183 of 2021 or the 277 and 278 of 2021, there is the removal of this concept of the firm, that the firm would have been entrusted subsequent to the application process under the Central Tenders Board to carry out the recruitment and appointment exercises. A firm with significant repute going through a rigorous exercise within the public domain would be entrusted with this activity. A firm with the level of resources and expertise to conduct such an exercise. And their activities would have been overlooked and guided by the Police Service Commission. A report would have been produced for the Police Service Commission to also check and ensure that the things that were being done were actually being done. Security vetting and whatnot would have also been part and function of that firm. And this concept of the firm, in my opinion, lent to a belief then that there was a significant degree of independence away from any administration. And what has come before us in triplicate rather, the 183, the 277 and the 278, is a complete erosion of this firm. The firm would have also been charged with the responsibility to prepare a dossier so that when the matter would have come before the Parliament, parliamentarians would have had the ability to review the dossier and debate accordingly. And that was removed in the 183 of 2021 order and then replaced...
Senator,
yes.
I've given some leeway in the start of your contribution because, as is expected, some sort of a context would need to be created. At this juncture and where you're coming in the debate, when that context runs on the way it has so far, you run into tedious repetition. So we've heard about 183, we've heard about everything that has come before. What we're dealing with before us is 277 and 278. So I'm going to ask you at this point, if you have any new points that haven't been stated before in relation to these two legal notices and this motion, that Senator Mark has raised, bring them forward now, because what will happen is you will run afoul of tedious repetition.
Guided. And so what you had happening with respect to these situations now not being included in the 183 order, it was eventually replaced and a similar dossier position was put in 277 and was not affected by 278. I also had an opportunity in terms of briefly looking at 183 and 277. I recognized that in comparison, there's this element of restricting the commission in 277 to utilize advertising the position in local newspapers. Now, I would have listened to the good uncle, Senator Clarence Rambharat, where he spoke about persons from foreign countries coming to Trinidad and Tobago to take up that position of police commissioner, and how difficult such a role would have been and a position for them to adopt. But I would have to disagree. I think giving, be it the firm or the commission, the latitude to allow for persons of international and regional expertise to participate in the application and recruitment process would have added considerably to the HR in terms of Commissioner of Police and Deputy Commissioner of Police. And in terms of reviewing that particular position, I recognize that in the firm aspect, the firm would have had a website. When I tried to see whether or not in this particular situation, what steps or measures would have been available for the commission now to invite persons of local, regional or international repute to apply, the Service Commission does not have a website. They have a Service Commission Secretariat. And one would hope then that that Secretariat has the level of resources to ensure a smooth recruitment process, because this is what these two orders would have now placed upon or entrusted upon the Commission to conduct all these activities that are well named in these two orders as opposed to the orders previously. In terms of the 2009 order, which was really and truly only properly well affected by the 277 order, I mean, it has been spoken about by other contributors here this evening that there was an attempt that was made by Order 183, and that attempt would have failed. The courts didn't find favor with it. And so an attempt was made in 277 to treat with that properly and frontally. I do, in fact, have some issues with that. Now, one of the issues that the court had with the 2009 order, which was attempted to be fixed in the 277 order, is that there was no room for parliamentary debate of persons in those acting positions in the 2009 order. And albeit, yes, that it was in contrast to the Constitution, it could have been fixed. Do I think that the 277 order fixes it? In my opinion, no. You have situations where persons would be attempting to act in a position, Commissioner of Police or Deputy Commissioner of Police. In some instances, the turnaround time for that acting position could be as little as 1 or even 2 days. And what the 277 order envisions now is that a list also has to be prepared for those persons to assume those roles and responsibilities. Whereas what took place in 2009 is that if you wanted to act as Commissioner of Police, it would have been the most senior person holding the position of Deputy Commissioner of Police or acting in the position of Deputy Commissioner of Police would have been entrusted in that role. And equally as it pertains to persons who had to act as DCP, it would have been the person most senior either holding the position of ACP or acting in the position of ACP on the advice of the Commissioner of Police or in consultation with the Commissioner of Police would have been given that opportunity to act. And so the turnaround time would have been realistic. What is envisioned here, in my humble opinion, is not. And yes, the court would have indicated certain things that have been hashed by many other speakers here today. But it still doesn't form part of what I think is a realistic representation of what actually happens within the service. And I can very well imagine whenever such a time arises, there will be some difficulties. And so if there's an opportunity to fix the situation, it should be done on the floor of the Parliament. Now, in an attempt, as I said, my intervention here this evening would have been quite minor, so that I don't intend to detain any persons much longer. The crux of the motion is this, Mr. Vice President. We believe that it is high time for persons to understand that the level of transparency that is supposed to be associated with the process, in our respectful view, does not exist. That there is significant interference within the process that should not exist. And that if what transpired in 2021 is ever allowed to happen again, you're going to be putting the country at significant risk. You cannot have a situation, with the greatest of respect, Mr. Vice President, where a process or procedure is supposed to be transparent, void of political interference, taking place in the year of 2021, taking place rather actually as far back as the year of 2018 or 19, when an appointment process was taking place, an individual may have been fifth or fourth or whatever on the list, did not find favor, or the other persons higher up did not find favor with the government. Those four would have been felled, and one would have been trusted to the top. And then 3 years later, as the old people say, after each a vomit, and turn around and call the same person disrespectful, and go through a level of gymnastics unseen in this country to treat with that situation. And that is all we as a responsible opposition, that is all we are trying to put onto the floor of the parliament, to put on the Hansard, to put on the record, and most importantly, to create those seeds in the minds of the listening and viewing public so that they properly appreciate what would have transpired within this chamber. Wherever change could be made, we hope that it is effected properly, and going forward, no pun intended, sober minds get to work and actually get the job done. I thank you.
Senator Vieira.
Thank you, Mr. Vice President. Given the state of crime in the country, the public is justifiably concerned that the best person for the job is appointed as Commissioner of Police. Now, I'm not for or against any particular candidate. Happy to leave those determinations to the Police Service Commission and to the Parliament. The issue really is whether these notices are a clever way to gerrymander or manipulate the system, thereby allowing the government to get a commissioner of its choice. My role as an independent senator is to weigh the pros and cons of the motion and then to vote accordingly. Now, so this is an important motion because it enables us to deal frontally with the selection and appointment of our Police Service Commissioner. And it also enables the public to hear about these two legal notices, their purpose, and to gain a better understanding of the issues. So we have to thank Senator Mark for bringing it to the fore. The motion requires us to consider two narratives. Senator Mark's narrative that this is an attempt by government through legalism to undermine and manipulate the Police Service Commission. And the Attorney General's counter-narrative that this is an attempt to better regulate the selection process in keeping with the Constitution and applicable jurisprudence. Is this, as Senator Mark posits, an unlawful attempt by the government to prescribe how the Police Service Commission should go about selecting the commissioner and deputy commissioners in abrogation of the Police Service Commission's prerogative? Or is this, as the Attorney General points out, not about trying to manipulate the Police Service Commission, but about ensuring that the Commission is able to select the best person for the job, among other things by removing the fetter of seniority and ensuring that the criteria and procedures are constitutionally in order? During the debate, a number of cases were referred to, treating with the role of the commissions and their independence. I'm not going to rehash those cases. Suffice to say, I don't see these orders clashing with the case law or undermining the independence of the Police Service Commission. In any event, if one reads the relevant sections clearly, there are no breaches of the Constitution. As other speakers have pointed out, the critical section is Section 123 of the Constitution. And I will also look at Section 129 and Regulation 24 of the Police Service Commission regulations, because these were cited by Senator Mark. Let me start by drawing reference to Section 123(9), which makes clear that the Police Service Commission may prescribe the procedure for termination. Now, if there was another subsection which made clear that the Police Service Commission shall prescribe the criteria and procedure for appointments, that would be the end of the matter. But there is no such provision. In fact, subsection 2 says that the Police Service Commission shall nominate persons for appointment in accordance with the criteria and procedure prescribed by order of the President. And as Senator Mark rightfully pointed out, what you're really saying here is as prescribed by the Cabinet, subject to negative resolution of Parliament. So the salient point here is that the Constitution recognizes that the criteria and procedure for appointment is not made by the Police Service Commission, but by an order of the President, and the check and balance is Parliament. If it's unpalatable, it can be negatived by the Parliament. Interestingly, Senator Mark cited Section 129, which recognizes that a service commission can regulate its own procedure by regulation or otherwise. But if you read that section, it also says that requires the consent of the Prime Minister. So had the Police Service Commission come up with its own criteria and procedures for the appointment process, it would have required the approval of the Prime Minister. And without such approval, those procedures and processes would be unconstitutional. So accordingly, I see nothing in the orders which breach the Constitution where that is concerned. Turning now to the issue of seniority, of which we have heard much. Senator Mark posits that seniority should not be removed as the determinative factor, and that was echoed by Senator Lutchmedial. And he cites Regulation 24 of the Police Service Commission regulations in support. Well, I agree with Senator Rambharat, who points out that Regulation 24 does not arise in relation to the appointment of the police commissioner. But for me, the more important consideration relates to what the Attorney General properly touched on, the fettering of discretion point. Now, what's a fettering of discretion? A fettering of discretion occurs when a decision maker is bound by a particular policy. So if I have a decision to make and I'm supposed to have a wide discretion, and there is something that fetters me, prevents me from really exercising my discretion as I feel I should or I would like to do, that's a fettering of discretion. And it could come in all kinds of ways. So if seniority is the determinative factor, it means that the commissioners are not free to consider all the relevant factors and the specific circumstances in relation to each candidate. If the principle of seniority is the determinative factor, it undermines the whole recruitment process and the selection of the most suitable candidate. Now, don't get me wrong, seniority matters. And there's nothing here that says that seniority will not be considered. Yeah? I expect that the commissioners will weigh seniority as a factor, but it will not be solely determinative. So by removing seniority as the determinative factor, we are in fact empowering the Police Service Commission. We are giving them the leeway. We are giving them a broad discretion in selecting the best candidate. So I fully support the removal of this fettering of discretion. In conclusion, there's a lot of noise about government trying to gain control or influence the appointment of the police commissioner. But honestly, I see nothing in these orders that conflict with the Constitution or that will undermine the role and independence of the Police Service Commission. In fact, when you read the order, it reiterates that it is the commission which conducts the recruitment process. It is the commission which ensures that the candidates are subjected to security vetting. It is the commission that conducts the assessment. It is the commission who shall select the most suitable candidates, and ultimately, the best candidate, the highest graded candidate. So I do not see these orders as an attempt by the executive to gain control over or to unduly influence the appointment of the police commissioner. Rather, they are about ensuring that the Police Service Commission has a clear and unfettered path in carrying out the selection process. We have a new Police Service Commission manned by some very eminent persons whose probity is beyond reproach. This will help them to do their jobs without blinkers or interference. What matters now is that they get on with it. I thank you.
Senator Mark. Senator Mark.
Yes, thank you, Madam President. Madam President, may I ask how many?
You have 30 minutes.
Okay, thank you. Okay, thank you, Madam President. Yeah, Madam President, I'd like to begin by thanking all of the speakers who have contributed to this motion, which seeks to have legal notices 277 and 278 annulled. we had at least we had the Attorney General, we had Senators Hazel Thompson-Ahye, Senator Roberts, the Honorable Clarence Rambharat, Senator Varma Deyalsingh, Senator Jayanti Lutchmedial, Dillon-Remy, Sean Sobers, and the last speaker, Senator Vieira. Madam President, I want to say from the very outset, that the last time I brought a matter, a motion I should say, to have Legal Notice 183 annulled, like today, it did not find favor with my colleagues on the independent bench. But I must say that history has absolved me. Because not only did Justice Nadia Kangaloo said paragraph 4 was superfluous and had to be struck out, the government of Trinidad and Tobago has now deemed Legal Notice 183 as literally irrelevant by its revocation. So if Legal Notice number 83 was good, then the government would have kept it. The government chose to remove it completely, Madam President. So I want to indicate from the outset that we are not the courts. Only the courts can decide these matters. Whether we are wrong and my colleagues on the government bench and the independent bench are right. But our responsibility, Madam President, is to ensure, like all of us are on the same page, we want to ensure that there is no influence, there is no interference, there is no manipulation, there is no gerrymandering by the ruling party, whichever one is in power, in determining who shall be the next Commissioner of Police. Madam President, I want to say that in the case of Senator Dillon, Senator Dillon made reference to some discussion she had with some unnamed police officer on this whole matter of whether this question of seniority is relevant, and the person told her, in essence, this is something that they need to look at and deal with, and they believe that the Police Service Commission, should really take into account, factors, other than, because that thing is more or less, that is the seniority concept. Seniority concept seems to be a bit outdated to some extent. Madam President, in the Police Service Act, Section 131, in spite of all that we have been told today, it is entrenched in law that seniority as an element in determining, Madam President, whether someone should be elevated to one rank to the next, is the law of the land. And in spite of what my colleague Senator Rambharat would have us believe in terms of the 206 discussions, bipartisan discussions, the law of the land remains that seniority must be considered, Madam President, when you are dealing with acting appointments in the police service. It involves not only acting appointment at the level of the Commissioner of Police, the Deputy Commissioner of Police, but other ranks in the police service. So I reject completely the argument that has been proffered that seniority is not essentially relevant to what we are dealing with. And Madam President, may I also indicate, when my colleague Senator Rambharat made a reference to myself supporting the 206 bipartisan legislative arrangements, he was absolutely correct. We supported it. But I want to remind you, Madam President, Honorable Madam President, and through you to the Honorable Clarence Rambharat, that when you go to the Hansard records that led to that final agreement and passage of the legislation, you would have seen, Madam President, that those negotiations were very difficult, very challenging. And many things that we wanted as an opposition in that piece of legislation that is now part of the Constitution, we didn't get them, Madam President. We wanted to have the power to appoint 2 members to the Service Commission, and the PNM should appoint 3. We didn't get through. But in the spirit of bipartisanship, Madam President, we agreed. So to give the impression through my honorable friend that we agreed to everything, and therefore, what am I talking about as it relates to seniority? You already agreed to that in 2006. And it happened even before you agreed in 2006. And I'm saying that I want to refer my colleague to the Hansard record. And the Hansard record would show that the then Prime Minister indicated that these were difficult negotiations. And he's even on record as saying, Madam President, and I just want to remind my colleagues, even the former Prime Minister, and that is why when Madam President, the Honorable Attorney General, in his contribution, made reference to acting appointments in the police service, and he went on to say, Madam President, that if somebody is acting for a day, given the revocation of 103, legal notice number 103 of 2009, you have to come to the Parliament to get approval. And he said that would be wasting time. And therefore there's need for what? Bipartisan negotiations. And maybe we can deal with these matters of acting on a short-term basis rather than on a daily basis. Because that would be it would consume, Madam President, a lot of time. And I said, look, this would be a wonderful opportunity for us to reform the Constitution. So I from a personal point of view, I would welcome such discussions, Madam President, because there are many things we want inside this Constitution that is not currently in here. And I think that the negotiation would give us the opportunity to bring those to the attention of the government. I remember, Madam President, Mr. Manning at that time did not want affirmative resolution as it relates to notification and the Parliament engaging. He fought against that. But again, in the spirit of the occasion, he had to give in because we did not give in to that as it relates to removal. He wanted negative, we maintain affirmative. And Madam President, just to clarify one small point, so I could put in the record the need for clarification and somewhat an understanding of the challenges. And I was very happy as well when the Attorney General said the law is a living organism. It is a living organism. It's dynamic. It is not static. And here in the Hansard record on page 5 of the 15th of March 2006, between the hours of 5:30 to 5:57 p.m., I want to quote what the former Prime Minister Patrick Manning, may his soul rest in peace, said, and I quote, Madam President, Mr. Speaker, that this approach does not represent us an ideal, rather it is a compromise approach to which we have agreed to subscribe, and we will see over time, with the effluxion of time, how well the system works, how well it does not work. And he said, if it turns out that the system is not meeting the aspiration of the honorable members of this House, then we believe we possess the maturity, again, to sit around a table and continue our search, Madam President, for an approach that more closely meets the requirements of Parliament within the context of the society in which this Parliament operates. End of quote. Madam President, I raise this to let you know that this is a work in progress. And it is totally wrong for anyone to give the impression to this Senate that everything was hunky-dory. No, everything was not hunky-dory. Everything was not all acceptable. Madam President, I want to go to this point about the fettering that was made by my colleague, Senator Vieira, of the Commission. And the argument was put forward that this 277 and 278 is not fettering the discretion. In fact, it is expanding, it is enhancing the discretion, and that we have excellent people at the level of the Commission, headed by a former appeal court judge. Madam President, may I remind this Honorable Senate that under 123(2) of this Constitution, the executive arm of the state has the power, through the selection criteria and procedure, for the nomination of a Commissioner of Police and a Deputy Commissioner of Police, 3 of them. They have the exclusive power to determine the criteria and the procedure, which again, Madam President, is reflected in notices, legal notices 277 and 278. So, Madam President, if we are being told by the Minister, the Honorable Minister of Agriculture, as well as the Attorney General, and supported by Senator Vieira indirectly, that 129(1) of the Constitution allows the Commission to make regulation with the consent of the Prime Minister, which is absolutely true. The question that has to be asked is that in the police service regulations, which is appended to the Constitution, what are those regulations for, Madam President? Who do these regulations refer to or apply to? Madam President, I would argue that under the Constitution of our country, and I refer to 123(1)(a), that deals with the appointment to hold or to act in the offices of the Commissioner of Police and the Deputy Commissioner of Police the power to appoint those office holders only by the Police Service Commission, Madam President. If that is so, Madam President, and the police service is bound, Police Service Commission, under 123(2) to follow the criteria and procedure as outlined by the executive. Madam President, if the executive placed in an order 277 the sending order of seniority, and within 24 hours removed it, Madam President, what does that tell you? Madam President, in the legal notice of 2015, Justice Raj Kumar left the commission to engage to engage a firm to help it in the assessment and recruitment exercise. In legal notice 183, it was removed. I asked then to the Attorney General whether that is going to hamper the commission from doing its work. The response was no. The commission can still proceed to hire a firm, both for the substantive as well as maybe the acting. Madam President, I made it very clear that time we should have put or left in the legal notice the power of the commission to select a firm of choice to help it. That was removed. Madam President, in the 277 and 278 that we have before us, again, the government has left out the ability of the Police Service Commission to select a firm. I may be wrong, but my information is that the Police Service Commission has been conducting its interviews for acting police commissioner, for the deputy acting police commissioner, not on the basis, Madam President, of any firm, but they are doing it on their own steam with the support, I guess, from the Secretariat, which is the DPA. If I'm wrong, I am prepared to give way. But that is the information I have in my possession. So if, Madam President, it is correct what I have said, Madam President, then by leaving out the firm and leaving it up to the discretion of the Police Service Commission to engage a firm, the Police Service Commission, for all intents and purposes, it is alleged, has not done so. Yes, but Madam President, they have the discretion, we are told, to do so, but they have not done so. So it is the same argument that is being made here. The government has put into 277 seniority and then came back, Madam President, in less than 24 hours and they removed it. And then we are being told that that is not fettering the discretion of the Police Service Commission to do their job. It is expanding their discretion. How can you be expanding the discretion of the Police Service Commission when you have removed it, Madam President? But Madam President, you know why there will be a clash in the laws here? In the Police Service Commission regulations, which was passed in this Parliament, and the last set of amendments came in 2006, and the Police Service Commission is responsible, Madam President, for the appointment for acting purposes of the Commissioner of Police and the Deputy Commissioner of Police. In those very regulations, Madam President, there is a general rule that talks about seniority. So if there's a general rule, Madam President, that talks about seniority under 129(1), which gives them the power to make regulations. The regulations are attached to the Constitution. But then in 123(2), the government has the power to determine the criteria and the procedure. And the government is saying in these two legal notices, Madam President, that you, the Police Commission, is not directed to consider seniority. How are they going to exercise their discretion if 123(1) trumps 129(1)? So at the end of the process, Madam President, the government is directing the show. The government is directing the Police Service Commission what to do and who to select and who to put the act and who not to put the act, Madam President. And we are saying in this Parliament, essentially, Madam President, this is okay? Madam President, the Parliament will not be able to determine this. Only the courts of our country, up to the Privy Council, will determine this. And it will show again whether we were right or we were wrong. But we will not stand idly by and allow these motions, these legal notices, to go unchallenged, to allow the present executive to determine who will act as a commissioner of police, who will act as a deputy police commissioner, Madam President. We will not permit that. And history, as it has already absolved us in round 1, it will absolve us in round 2, Madam President. So, Madam President, let me just deal with this point, because this is a point that I championed during my contribution, and my colleagues who contributed to this motion sought to debunk this idea of seniority. Almost to say that seniority has no place in the mobility or the upward strides of a police officer, Madam President, who is elevated from one rank to another based on his hard work, his experience and qualifications. Madam President, and may I say something immediately? Let me disabuse from the minds of my colleagues. I am not at any time saying, Madam President, that seniority is the only criterion that must be used to determine someone's elevation from one level to another to act. I can't be saying that. I'll be a madman, Madam President. Seniority is one element. Qualifications is one. Experience is two. But what I'm saying is that what we are putting in this order is to tell the Police Service Commission, do not consider seniority. That is what the order is saying. But the regulations, Madam President, that is the Police Service Commission Regulations 24(1), is saying, as a general rule, seniority will be considered. So, what will prevail? Who will prevail? Legal Notice 277 and 278, Madam President? Or will it be, Madam President, the Police Service Commission's regulations, which is appended to the Constitution? Which will prevail? Madam President, in the event of confusion, there will be need for legal clarification. There will be need for legal certainty. Because right now, the legal notices are ambiguous, Madam President. And the only way that matter will be resolved is in the courts of Trinidad and Tobago to determine whether the executive, Madam President, there has been an incursion.
Senator Mark, you have 5 more minutes.
Yeah, there has been an incursion once again by the executive in determining who will become Commissioner of Police, who will become a Deputy Commissioner of Police, who will act as a Commissioner of Police, who will not act as a Deputy Commissioner of Police. Madam President, today in Trinidad and Tobago, because of executive interference, we don't have a substantive police commissioner in our country for the first time for a few years well. And that came about, Madam President, because of the gerrymandering, the interference, the manipulation of the whole process, the interference, the influence. And we are seeing this occurring once again in these two legal notices. Madam President, we will not stand idly by and allow the PNM government to manipulate the process to determine who will be our next Commissioner of Police or who will act as a deputy. The court will have to intervene and settle this matter once and for all. Madam President, we had a duty. The courts will know when we go before them that we came to this Parliament, we executed this case. The Parliament took a decision, was not in favor of annulment. Hence the reason we have to come to the court to get the court to give us direction on this matter. And only the court can decide this matter at the end of the day. Madam President, I want to thank you for giving me the opportunity. And through you, I want to thank all my colleagues who have participated. I fundamentally disagree with all of my independent colleagues on this matter. I respect their views, but I disagree with them on their submission. We fundamentally disagree with the Attorney General and the Minister of Agriculture on his submission or their submission. It is consistent with what they did in July of 2021 in terms of their submission when I brought a similar annulment motion. It is being repeated today. We have no problem with that. We did our duty. The population will have clarity. They will look at what has happened in the Parliament and they will make a determination. At the end of the day, we have only one thing to do, Madam President. That is our duty to our country, to the Parliament, to the people, to the community. We have done our duty, and Madam President, once again, I beg to move, and I thank you very much.
Minister in the Office of the Attorney General and Legal Affairs.
Madam President, respectfully, I stand on Standing Order 44-2, exercising the government's right to respond. Madam President, I thank you most sincerely for the opportunity to make a very quick contribution to this debate. I have had the opportunity to sit and listen to the contributions made by those opposite, and most certainly by the independent bench. Madam President, while my contribution certainly is not going to be long at all, because I know the Attorney General and Minister Rambharat would have, traversed the government's position, I felt it was necessary, just as a matter of for the record, to add my 2 pence to this very critical motion that has been brought by Senator Mark. And why I refer to it as a critical motion is because there was so much misinformation and misguidance presented by those opposite that I felt the need to rise and make a very simple contribution. Now, Madam President, the effect of the Commissioner of Police and Deputy Commissioner of Police Selection Process Number 2, Order 2021, and the Amendment Order 2021 on the Commission's exercise of its powers relating to the appointment of the Commissioner and Deputy Commissioner of Police is what, in essence, is before us today. Madam President, as a matter of the record, those powers, like those in Section 123(1) of the 1976 Constitution of Trinidad and Tobago, includes power to appoint persons to hold or to act in the office office of the Commissioner or Deputy Commissioner of Police, and the power, as we all know, to make appointments on promotion and to confirm appointments, as well as the power, Madam President, to remove from office and exercise disciplinary control over persons holding or acting in the offices of the Commissioner and Deputy Commissioner of Police. Now, Madam President, in respect of each of these autonomous commissions, the Constitution, and I say the Constitution, contains provisions to secure its independence from both the executive and the legislature. And this is very necessary for us to understand. Further to that, Madam President, the role and function and constitutional independence of the Police Service Commission, established under the 1962 Constitution, were also considered, Madam President, in great detail in a case that lawyers are very much familiar with, the case of Thomas versus the Attorney General of Trinidad and Tobago, an appeal case. In that case, Madam President. So there was this case, that was considered in great detail. And as I said before, that case is Thomas versus the Attorney General. Of course, it's a case that is referred to often in our jurisdiction. Now, in this particular case, Madam President, Lord Diplock actually stated the functions of the Police Service Commission fall into two classes. One, to appoint police officers and to the public service, including their transfer and promotion and confirmation in appointments, and two, to remove and exercise disciplinary control over them. Now, Madam President, although Thomas dealt with the 1962 Constitution, it is necessary for the record to state that the Privy Council, per Lord Diplock, expressly observed, Madam President, and noted at 120E that its comments in relation to the constitutionally protected autonomy of that and other service commissions, and note, other service commissions were equally applicable to the 1976 Constitution. And this is something that I felt it was imperative to place on the record, that case, and some of the dicta coming out of that particular case. Now, Madam President, in relation to the Police Service Commission, the principles established in Thomas in relation to the 1962 Constitution survives even today, after the Constitution was amended in 2016. Now, I know Senator Lutchmedial would have also mentioned, because she was indeed a part of that Haridat Mirage case. And I myself want to add a little something on my interpretation and the interpretation of the Haridat Mirage versus the Attorney General of Trinidad and Tobago case. Now, this, Madam President, in a nutshell, it dealt with the constitutional jurisdiction of the Police Service Commission and whether the order was unjustifiable and an unlawful fetter and interference with the independence, jurisdiction, power, role, and function of the Police Service Commission. Now, in that case, which I just pulled at paragraph 27 of that case, Madam President, on one hand, there is the function, and at paragraph 27, Madam President, it states, on one hand, there is a function of appointing officers to the police service, including their promotion and transfer. In this case, was a matter exclusively for the Police Service Commission. On the other hand, Madam President, there are terms of service which are to be included in the contract of an individual police officer. The Police Service Commission does not employ the police officer. His contract is within the executive. Now, it was concluded in the case, Madam President, a few things. One, the amendment of the Constitution in 2006 did not remove the Police Service Commission's independence or autonomy in relation to the appointment to offices of the Commissioner of Police and Deputy Commissioner of Police. The case in a nutshell also said the order providing as it does for the role of the minister in triggering the recruitment process, is, in that respect, ultra-virus the Constitution. Now, Madam President, let us put that into context in the matter, in the motion that appears before us. Now, Madam President, as I said, let us put this into context of where we are today. The Commissioner of Police and Deputy Commissioner of Police, Madam President, selection process number 2 order 2021, and the Commissioner of Police and Deputy Commissioner of Police selection process number 2, Amendment Order 2021, says, and I want to reiterate this, says specifically that it is the Police Service Commission that it is the Police Service Commission in its sole discretion that can appoint a person to act in the office of the Commissioner of Police or Deputy Commissioner of Police. However, its discretion is limited only with respect to the pool of candidates. However, note, its discretion is limited only in respect to the pool of candidates from which to choose an appropriate person to act as the Commissioner of Police or Deputy Commissioner of Police. Now, Madam President, in the interest of this government, in the interest of the PNM government, in the interest of the government for all the people of Trinidad and Tobago, in practicing good governance and upholding the separation of power, the orders therefore do not diminish the role of the Police Service Commission. We therefore cannot force them to act, Madam President. We are not here to force the Police Service Commission to act. They are there functioning autonomously without the influence of anyone, Madam President, other than themselves. So as I close, Madam President, I wish to emphasize that we, the government, is saying, should someone be appointed, they should hold the necessary qualifications and experience and special training for that position. I also reiterate by saying Senator Mark's motion, it fails miserably. Madam President, with those few words, I thank you most sincerely for the opportunity to make a small contribution to this debate.
Honourable Senators, the question is, be it resolved that the Commissioner of Police and Deputy Commissioner of Police selection process number 2 order 2021 and the Commissioner of Police and Deputy Commissioner of Police selection process number 2 amendment order 2021 be annulled. Those in favour say aye. Those against say no. Honourable Senators, you will remember that because we don't have everyone in the chamber, I will allow 3 minutes for all members to return to the chamber.
there, right? During the announcement, and then indicate.
Honourable Senators, I wish to advise that I have granted permission to Senator the Honourable Amory Brown, Minister of Foreign and CARICOM Affairs, Senator the Honourable Hazel Backus, Minister of Digital Transformation, to participate in these proceedings virtually, and these senators will therefore be called upon to vote.
Mr. Rambharat?
No.
Ms. Gopi Schoon? No. Mr. Sinanan?
No.
Mr. Hussain? Ms. West? No. Dr. Brown?
No.
Mr. Mitchell? Ms. Cox?
No.
Mr. De Freitas?
No.
Mr. Singh?
No.
Ms. Sagramsingh-Sooklal, sorry.
No.
Mr. Backus?
No.
Mrs. Lizama Leasing?
No.
Ms. Bethalmi?
No.
Dr. Abraham?
No.
Mr. Mark?
Yes.
Ms. John?
Yes.
Ms. Lutchmedial?
Yes.
Mr. Lyda?
Yes.
Mr. Roberts?
Yes.
Mr. Sobers?
Yes.
Mr. Richards?
No.
Mr. Vieira?
No.
Dr. Deyalsingh?
No.
Ms. Dillon-Remy? Ms. Sipasad?
No.
Dr. Timau?
No. Yeah.
Sorry, Mr. Timau? And Dr. Burgess?
No.
Six voted yes. Honourable Senators, the result of the division is as follows. 6 senators voted in favour of the motion, 21 senators voted against the motion, and no one abstained. The motion, therefore, is not carried. Leader of Government Business.
Madam President, I beg to move that this House do now adjourn to tomorrow, Wednesday, 26th January 2022 at 10 a.m. Tomorrow, Madam President, we will deal with the Finance Variation of Appropriation Bill 2022. Thank you.
Honourable Senators, before I put the question on the adjournment, leave has been granted for one matter to be raised. Senator Mark.
Thank you, Madam President. Madam President, the matter deals with, and I quote, the need for the government to address delays in the treatment of children affected with cancer because of the non-functioning PCR machine at the Mount Hope Hospital. Madam President, based on my last investigation, the 2 PCR machines used to test both parents and cancer children are not fully functional. At the JBS Cancer Children's Ward at the Wendy Fitzwilliam Hospital, Children's Hospital at Mount Hope. At the moment, based on my understanding, there's only one PCR machine currently working.
May I remind members that we are still having a sitting?
At the moment, based on my understanding, Madam President, there's only one PCR machine working at this children's hospital to service both children and parents or adults. Madam President, when samples are taken, they take a long time for results to come in. It is our view that samples taken must be prioritized in the system in order to promote greater levels of efficiency, Madam President. My understanding, and I stand to be corrected, that untimely treatment of cancer children can lead to relapses, which can pose serious dangers to the very lives of these innocent cancer children. It is therefore imperative that all steps and measures be taken by the hospital administration and the government to prioritize the processing of these samples so that the treatment protocols can be scrupulously followed. At the moment, Madam President, I have been informed that there exists only one PCR machine operational to satisfy the needs of both parents and cancer children at the Wendy Fitzwilliam Pediatric Hospital. My further understanding is that this single PCR machine is also being used for the entire patient population. This is unacceptable. Madam President, this, as I said, is totally unacceptable. There should be a minimum of 5 PCR machines in this society at that particular hospital functioning on a daily basis in order to ensure that citizens, particularly children suffering cancer, can have access. And Madam President, particularly also during this pandemic period. Another area of grave concern, Madam President, is the inability of parents and cancer children being able to take their samples involving both the PCR and the antigen swabs at the same time and on the same day. Now, because of the failure of those in authority to treat with the proper functioning of the machines at the hospital, parents and cancer children are now being asked or requested to take the PCR on one day and return 3 days later to do an antigen test in order to access treatment at the facility. Again, this is absolutely unacceptable. This results, Madam President, in severe dislocation and hardship for both parents and cancer children who are now being forced to engage in extra expenses which they can least afford at this point in time. Parents, Madam President, who happen to be working parents are forced to take at least 2 days off their jobs in order to access testing at both levels, namely the PCR and the antigen tests. Madam President, it is to be noted that many of the cancer children reside in the southern parts of this country and have to trek sometimes hours to reach their destination. Madam President, another issue plaguing cancer children or children with cancer in this country, again, is tied to the PCR results. When, Madam President, they become ill with a fever, that is the cancer children, or anything at all, they are tested on what is called the emergency department, where both PCR and antigen samples are taken and then moved to another pediatric ward that is not oncology oriented, posing life-threatening conditions to these children, as the nurses and doctors in these medical and surgical wards may lack the knowledge and experience to handle what is called, Madam President, the ports or portal cath, by which the children receive medicines in their bodies. Madam President, this can cause these ports to become infected, and they can do grievous harm to these children and their organs. In those circumstances, Madam President, I am calling on the government to do the following immediately. The government should immediately, upon these children taking PCR samples, these samples should be immediately processed and these children be consequently moved to their oncology ward, where they can receive their medical treatment by trained personnel on the spot, and thereby avoid in the process the possible loss of life and unnecessary suffering that these cancer children can experience and undergo. So, Madam President, I have brought this matter to the attention of the government for its intervention and consideration to ensure that cancer children and their parents are given priority at the particular hospital where they are treated, that is the Mount Hope Medical Eric Williams Sciences Complex, and I'm talking about the GBS at the Wendy Fitzwilliams Pediatric Children's Hospital. Madam President, I thank you.
Leader of Government Business.
Thank you very much, Madam President. Madam President, before I respond to Senator Mark, I want to just say that two of our colleagues recently just created history a short time ago by participating in these proceedings virtually. I want to thank you, Madam President, and the clerk and the staff of the Parliament for facilitating this. And I know many of my colleagues would like to see it be a permanent part of the proceedings of this House and this Parliament. Thank you very much. Madam President, I'm personally aware of the difficulties initially faced by the parents and the children who are cancer patients, and it had to do with the fact that the PCR machine within the NCRHA, North Central Regional Health Authority, was down on Tuesday, 28 December 2021. But in the interim, Madam President, there are procedures, there are protocols for those instances where critical equipment becomes non-functional in the public sector, and that protocol gives the opportunity, among other things, to have testing done in the private facilities, and that has been a long-standing arrangement. In this case, there would have been initial difficulties, as I said, because the arrangements within that particular NCRHA facility in respect of that particular PCR machine would have been disrupted. Madam President, the Minister of Health assures that those families were able to have the test done within 24 hours and the results obtained. Because of the breakdown of the machine, the procedures involving those particular patients were postponed on Tuesday, 28 December 21, and were performed 2 days later on Thursday, December 30th, 2021. Of course, it seems like a short time, Madam President, but I want to recognize, no disrespect to the families, the patients, the parents, that for a child dealing with the effects of cancer, 2 days, a 2-day delay would be almost equivalent to a lifetime for them, and we recognize that these things happen. Madam President, again, the PCR machine malfunctioned on Tuesday, January 4th, 2022, and those procedures which were affected were postponed on that day and were performed 2 days later on Thursday, January 6, 2022. And in none of these circumstances, the treatment and care of the patients were significantly compromised. But I acknowledge that any delay in these circumstances is a delay of significance to the parents and the patients themselves. As of January 12, 2022, Madam President, I'm happy to say that the machine was repaired, the PCR machine was repaired and became fully functional, and the patients, both at the operating theatre and the admissions to the wards, were receiving the PCR test results and follow-up treatment in a timely manner. Madam President, as I close, I just want to say that with the advent of COVID-19, Trinidad and Tobago was one of those few countries that's established a parallel healthcare system. Around the world, those countries which established such a system found themselves overwhelmed by COVID, and in many cases, the system that existed to treat non-COVID patients prior to the advent of COVID overwhelmed. And in Canada, for example, in Ontario alone, late last year, Ontario, for example, said there was a backlog of 1 million procedures, non-COVID procedures relating to the pandemic. We have been able to manage so far. Of course, the PCR is something that is also required for the COVID patients, and the rapid antigen testing is also required for PCR for the COVID patients. And while there have been some dislocations and some delays relating to the non-COVID patients, we managed to deal with a significant amount of the workload while dealing with the COVID patients. In fact, we've been able, Madam President, to make use of several of the private facilities, including the St. Augustine Medical Lab, Caribbean Forensics, Victoria Lab, Apex Diagnostics, Border Life Medical Lab, Medical Associates, and some others. And we've been able to continue dealing with both COVID-19 and non-COVID-19, including those children who are cancer patients and require this critical care. Thank you very much, Madam President.
Honourable Senators, the question is that this Senate do now adjourn to Wednesday, January the 26th, 2022 at 10 a.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Wednesday, January the 26th, 2022 at 10 a.m.